Good morning, Ms. Bia. Good morning, everybody.
Good morning, Chair.
Is everybody fine in the new year?
We are here, DC Chair.
You are here. Okay, are you ready?
Yes, thank you very much, Chair.
Okay.
This morning we will be dealing with the evidence of
I
Alexkor.
think you have a soft voice. You'll have to raise your voice and also make sure the mic, you're not too far away from the mic.
Thank you, Chair.
Yes.
Thank you, Chair. With me, there are some legal representatives of some of the parties that are mentioned in the evidence. If maybe they can place themselves on record.
Yes, let's take care of that. If you are able to do it from where you are, that's acceptable. If not, you can just have to switch on the mic.
Thank you, Chair. Duncan Wild, briefed by Webber Wenzel attorneys for Gamiro Advisory Services.
Thank you. I will have to double check whether the transcribers could hear you, because sometimes when the mask is on, when you have got the mask on, they might not be able to. Yeah, maybe just,
Thank you,
can
Chair.
just repeat, yeah.
I'll double. Duncan Wild, briefed by Webber Wenzel, acting for Gamiro Advisory Services.
Thank you.
Thank you, Chair. Azar Bar, instructed by Wandile Ndabambi of ENS attorneys, and we appear for the state time.
Thank you very much. Thank you.
Thank you, Chair. There had been an indication that there might be some issues in relation to the evidence that we intend to present this morning, procedural aspects. I just need to check with my colleagues whether they will be raising any of those issues.
Well,
prior to the start.
You can just press ahead. If and when they want to say something, they know what to do. Yeah, just press ahead, and if and when you reach a point where they have something, they will indicate.
Thank you, Chair. Chair, this morning we are dealing with the evidence related to mining. That's the mining stream, and the evidence specifically deals with Alexkor and irregularities that relate to Alexkor, which is a state-owned entity.
As you explain the evidence that will be led, just take into account that the members of the public
Yes.
might not even know what Alexkor is. Explain what Alexkor is and what's involved in the evidence that we'll be looking at, so that as the evidence is given, they will follow.
Thank you, Chair. Alexkor is a state-owned entity that deals in the mining of diamonds in South Africa. It reports to the Department of Public Enterprises, and the name derives from the area where the mining of diamonds was meant to be taking place, and that's in Alexander Bay. So Alexkor derives from that. The evidence that we will be dealing with came about when there was a whistleblower that came to the commission and indicated with some allegations in relation to the capture of Alexkor, and the nature of the capture that he indicated was that there was capture in two ways. There was the capture in the form of getting hold of the produce of the mines, which is diamonds. So getting access to that produce, and the other capture that was indicated was in redirecting the purposes of Alexkor from its main mandate of mining diamonds into mining coal, and thereby positioning it for entities that are linked to the Gupta family to be able to provide coal to Eskom. The minister at the time had agreed with the board in changing the direction of Alexkor into coal mining as well, but not to be performed in Alexander Bay, which is the place that Alexkor was created to serve mainly, but the coal was going to be mined in Mpumalanga and all the other areas that are not in Alexander Bay, and thereby redirecting all the focus of Alexkor and depriving the community that Alexkor was created partly to serve. This followed the announcement that there were going to be opportunities to serve Eskom by providing coal for them. Now, what happened was that the idea or the aim was to position Gupta companies to provide the coal to Eskom, and there has been evidence that relates to that. So Alexkor was also being positioned for that. The evidence, that was what the whistleblower indicated, but he also indicated other irregularities that were taking place at Alexkor. Having received that submission from the whistleblower, then the commission's investigators conducted their own investigation. And the findings that were made, or the conclusion that was drawn, was that the allegations that had been made by the whistleblower could be supported by the evidence that was uncovered by the investigators. So our witnesses will be, this evidence addresses the terms of reference 1.1 and 1.5 of the commission. And in Alexander Bay, there was a land claim that was made by the community of Richtersveld. They succeeded in their land claim. The effect of their success was that they could now have access to the land that had been allocated to Alexkor for mining. So a consent or an order by consent was taken by the parties to that litigation, which included the government of South Africa, Alexkor, and the community of Richtersveld, in terms of which it was agreed that there would be a joint venture that would be created that would represent the interests of the community as well as the interests of Alexkor. And that joint venture would, and part of the agreement was that the interest in the joint venture would be held in the following manner. Alexkor would have 51% interest and shareholding, and the community would have 49%. So in effect, a joint venture was then created, and the purpose, the agreement was that the community got access to the land mining rights. And Alexkor, which always had concessions to mine in that area, it had concessions to mine the land and also to mine the ocean. So there was also marine mining. And the result was that in terms of this agreement, the community gets 49% of the share in the joint venture, but they come with the land mining rights. And the Alexkor gets 51%, and it comes with the marine mining rights. So this joint venture meant that they were going to pool their resources together, so they would share in the benefits, which was good, given that the land available for mining, or the diamonds in the land, had been depleted, whereas the diamonds in the ocean had not been depleted. So it meant that while the community got this victory of being awarded the land that included a mining right, which could also have become an empty victory because there was very little left to mine. It meant that there was a benefit to the community by the formation of the joint venture and the fact that they were going to share together in the pooled resources. That is the nub of the evidence, but what also came out and what had been explained by the whistleblower was that the joint venture, although it had been established to ensure the interests of the community were guarded, had in fact appointed a contractor, which was not incorrect. They appointed a person or an entity that was going to be tasked with the marketing and sale of all the diamonds that were mined by the PSJV. So that meant that whether it's mined on the land or in the marine, it would go to this entity, and from this entity, it would be marketed and sold, and then the proceeds would come to be shared in accordance with the agreement. The allegations that came with the whistleblower indicated that the entity that was awarded the contract of ensuring, of marketing and selling the diamonds on behalf of the community, on behalf of Alexkor, on behalf of the joint venture, the evidence was that that entity was a Gupta-linked entity. So, and their powers were extensive because the miners themselves, neither the miners nor the joint venture could in fact value the diamonds that they were giving to this entity to market and sell. So they would take the raw material and give it to this entity, and only this entity could then determine this is how much we value these diamonds that you've given to us, and they had no way of double checking that. And then in the selling, what also came out was that there were no proper record to show who the sales were being made to and how much. So there was a lot of disgruntlement that had happened. There was an investigation that was commissioned by the Department of Public Enterprises, and our first witness will be talking to that investigation. We have witnesses that will testify today, that we have scheduled for testifying today. It's two witnesses. It's Mr. Torres, who is the author of the investigation report that was commissioned by the Department of Public Enterprises. And we also have Mr. Gavin Craythorne, who is the whistleblower that approached the commission. We also have other witnesses that we hope to be able to accommodate in the future that that will talk to the links in the evidence that was uncovered and tell and put the story all together. One is Jan Decker. He's a forensic accountant, and he conducted an investigation into the valuation process, among other things, and is able to talk to how much the diamonds were in fact undervalued, because his conclusion was that they were being undervalued by the entity. And the other witness is Peter Bishop. He conducted further investigations into the allegations by the whistleblower, and he drew conclusions from that, and he was able to go further than what the whistleblower had done due to the powers given to the commission.
Okay, thank you. Thank you. Are you ready for your first witness to take the oath?
Yes, yes,
Okay,
Chair.
please administer the oath of affirmation.
Please state your full names for the record.
My name is Alberto Torres.
Do you have any objection to taking the prescribed oath?
I don't have.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence will give will be the truth, the whole truth and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated. Yes, you may proceed, Ms. Sibia.
Thank you, Chair. Good morning, Mr. Torres.
Okay. Thank you.
Chair, if the Chair can have in front of him the bundle that is marked Mining Bundle 01.
Is that the bundle you are going to be using at the moment?
Yes.
Okay,
Thank
that's Mining Bundle 01. Right, yes.
Thank you. Mr. Torres, if I can take you, when I refer you to this bundle, I will be talking about the numbering on the left-hand side, where it's where it's typed in black, and where it says mining. If you turn underneath the flap that is marked 1.1, you'll see that on the first page that you open to, on the left-hand side of your page, it says mining 01001. Can you
Yes,
see
I've got
that?
it.
Okay. When I refer you to a page, I will not say mining 01 or 001. I will say page 1, and that's where I will be taking to. Okay. Thank you. Please look at that page.
Okay.
Are those your full names written there and your ID number?
Yes, it is.
Is that your initial at the bottom?
Pardon?
Your initial,
Signature, that's my signature.
your initials or your full signature?
The initials on page 1,
Yes.
and then I've got my full signature on page 2.
Okay. Do you confirm that this is a document that you prepared
Yes, I do confirm.
and that you deposed to it in front of a commissioner of oaths?
Yes, I do.
And do you confirm the content, that it's true to the best of your knowledge?
Yes, I do confirm the contents.
Have you had a chance to go through it just recently in preparation for today?
No, I've had a chance.
Thank you. Chair, with your leave, may I ask that this document that is marked, that is titled confirmatory affidavit, appearing on pages 1 and 2, that it be admitted as an exhibit, Exhibit XX 1.1.
Has it got any annexures or not?
It does, Chair.
It does.
Yes.
I see there is another affidavit by Ms. Dineo Petunia Tomo.
Yes.
Is that an annexure to Mr. Torres' affidavit, or is it a separate affidavit?
It's a separate affidavit, Chair.
So where are the annexures to Mr. Torres' affidavit?
In fact, Chair, Mr. Torres, maybe I should take him first through the sections that I wanted to take him, because it's a very short affidavit and it indicates what it is, what its purpose is. So it's titled confirmatory affidavit.
Well, before I admit it, I wanted to know whether when I admit it
With the
together with its annexures or
Yes.
it's not. That's why I'm asking whether it has got annexures.
It's got annexures, Chair. He refers to them
Are they
his
referred to in
character.
the affidavit?
Yes, yes, they are referred to, Chair, in his affidavit, and they appear from page 5, and they go all the way to page 1079.
Well, I think the problem is that the affidavit doesn't say, for example, in paragraph 4,
Yes,
what annexure the report is. It just refers to the report. Isn't it? That's right.
yes.
It looks like the report is the only annexure, is that correct?
No, Chair, the report itself has annexures to it.
No, I'm not talking about the annexures to the report. I'm talking about annexures to the affidavit, to Mr. Torres' affidavit. It looks like
yes.
the report is the only annexure to Mr. Torres' affidavit, am I
And
right?
then includes exhibits, yes, yes, Chair.
Yes.
Yes.
Okay, then I think Ms. Tomo's affidavit should not have been placed where it is placed, because if it is not an annexure to Mr. Torres' affidavit, and I understand why it should not, it should not come between Mr. Torres' affidavit and annexures to Mr. Torres' affidavit. That's not the right place.
Chair, I concede that. However, it was necessary to do it in this way because her affidavit also confirms the same report. They were working together. And whereas he confirms that he was the lead, she confirms that she was the junior that worked
Yeah,
together.
but it could achieve the same purpose even if it came after the report,
Yes,
isn't it?
yes, yes, I accept that, Chair.
Because it now comes between the affidavit of Mr. Torres and the annexures and documents or the report which is an annexure to that affidavit, and yet it is not an annexure to his
Itself
affidavit.
an annexure, yes, yes, Chair.
So it may be that it should be maybe you must think about where, are you going to be referring to it during
No,
his
Chair.
evidence?
We will not be referring to it as
Yeah,
evidence
maybe what
only.
you will need to do during the break maybe is to take it out from there and put it
Somewhere
after the
else.
report.
Yes.
And then then the numbering obviously will change. The best thing might be to not interfere with the numbering, if possible, and have it numbered right at the end or after the report.
We will attend to that, Chair.
Okay, all right. The affidavit of Mr. Alberto Torres, which starts at page 1, together with its annexure, namely the final report referred to in paragraph 4 of his affidavit, is admitted and will be marked as exhibit
XX 1.1.
XX1. So exhibit XX1 is Mr. Torres' affidavit together with the report, which is an annexure to the affidavit.
Thank you,
Okay.
Chair. Thank you, Chair. Mr. Torres, if we can go back to page 1, which
I
is,
think you need to move your mic a little towards the center because I don't think,
it doesn't move, so I need to move.
no, it should be possible to move it. Let somebody help you who. See, if you're speaking too far away from it, you can't be heard easily. Okay, all right.
Thank you.
Okay, let's start then.
Mr. Torres, I refer you back on page 1 of your affidavit. Do you confirm that at the time you deposed to this affidavit, you were an executive director at Gobodo Forensics?
Yes, I do.
Please speak closer to the mic. I
Okay.
think there'll be a similar problem. And when you answer, Mr. Torres, please look at the chairperson. So your neck will be sore, but you'll have to look at me when I ask questions, but look at the chair when you answer. Thank you. Are you still an executive director at Gobodo Forensics?
For Gobodo. I am a director of Gobodo. However, I retired now, but I am still a director at Gobodo.
Does that mean you are not executive director anymore?
No, yeah, I'm non-executive.
Yes, but you remain a director.
I remain director.
Yeah, okay.
Thank you. And do you confirm that Gobodo Forensic Audit was instructed by the Department of Public Enterprises to conduct an investigation?
Yes, I do confirm the Department of Public Enterprises appointed us to investigate this particular matter.
And can you explain to us the process that led to your appointment?
Well, we are on the panel for the Department of Public Enterprises. So being on the panel suggests that we have already been appointed based on our technical abilities. So we were requested to submit a quotation for the investigation into the irregularities at the Alexkor PSJV entity. And on that basis, we submitted a quotation and we were appointed. Okay.
What was the mandate that you were given?
Well, the mandate, in summary, they wanted us to investigate the relationship, the soured relationship that existed between the contractors on the one hand and the board and executive on the one hand. But there were also concerns raised by the contractors. And these concerns, some of the concerns were also identified as issues that had to be investigated. Okay, so that was.
Okay. And you conducted this investigation. How long were you given to conduct it?
We were appointed in about July 2019. We then had a 3-month window period to complete. So we submitted our report to the Department of Public Enterprises on the 14th of October 2019. So it took us about 3 months.
And how many of you were involved?
Only 2 of us.
Yes.
It was myself and the Neo, Tomo.
Yes. And you produced the report?
Pardon?
You produced the report?
Yes, I produced the report and I signed it.
Okay, and this is report you produced is the one that appears from page 5.
Okay. That's correct. Is the report.
And you were the author of the report?
I was the author.
Okay. Thank you very much. Now, if we can go to the report, and we can go, if you can turn to page 43 of the report.
Yes, I am there.
Is this?
Did you say 43?
Yes, Chair.
He may have given, Mr. Torres may have given the gist of their mandate, but I'm sure that in the report, that's one of the things they start with, to say this is our mandate. Maybe it would be good for you to direct him to that, but actually he probably knows it, so that he can just read that into the record.
Yes, thank you very much.
Before you move on.
That is where I was going, Chair, because it's in the paragraphs that appear on that page.
Oh, I thought it would be much earlier.
No,
Okay.
before this is the executive summary, Chair. So this is the actual start of
Or you
the
wanted
report.
you wanted to go to the executive summary, or this is the executive summary?
Yes.
Okay, all right.
Yes, thank you,
Okay.
Chair. So,
You can go ahead then.
thank you. Mr. Torres, if you can look at paragraph 2.5.
Yes, I'm there.
Please read that. And is it correct that that encapsulates what your mandate was, starting from 2.5?
Okay, can I read it?
Yes.
Yes, that was the mandate.
Okay. So your mandate, if you can start reading the Department of,
The Department of Public Enterprises seeks to appoint a suitably qualified and experienced service provider to investigate the legality of actions taken by the PSJV in the exclusion of the marine mining contractors and make recommendations arising therefrom.
yes, and if you go on to paragraph 2.6,
2.6, the DPE, which is the Department of Public Enterprises, wishes to establish the cause of the soured relationship between Alexkor, RMC, PSJV, and the marine contractors and make recommendations on improvements that can be made.
and paragraph 2.7,
The DPE further requires an investigation to establish whether the board and the executive of the Alexkor, RMC, PSJV exercised objective, fair, and transparent processes in the management of the operations.
is that everything that you were instructed to do?
Yes, but under our purpose and objectives, we actually break it down further.
Yes, we'll get to that.
Okay, but
Thank you.
in summary, that's what we were appointed to do.
Okay, thank you. Now you are talking about the PSJV. What is the PSJV?
The PSJV, I think you alluded to the fact that there was a deed of settlement, that in 2007, a deed of settlement between Alexkor on the one hand and government and the community of Richtersveld was made an order of the court, right? Now, in terms of the deed of settlement, an interim board, joint board, had to be appointed, and the board then had to establish a pooling and sharing joint venture, which would be made up of the Richtersveld community on the one hand and Alexkor on the other. So they refer to it as the pooling and sharing joint venture. So the abbreviation PSJV refers to the pooling and sharing.
So the Department of Public Enterprises gave you a mandate to investigate issues related to the PSJV.
Yes, the Department of Public Enterprises is the shareholder representative of Alexkor. And Alexkor was part of the pooling and sharing joint venture.
Yes.
They actually had a majority shareholding.
Yes.
And based on that, the Department of Public Enterprises appointed us.
Okay, thank
Sorry,
you.
Mr. Chair, I must still get used to
Nah, you will
looking
get
at
used. You will get used. Okay.
Okay.
Sorry, thank you very much. So they did not only limit your investigation to Alexkor issues?
No, our investigation was into the pooling and sharing, because
Yes.
everything that happened that we were investigating, we investigated for that period when the PSJV was already in existence.
Yes, okay.
Sorry, Mr. Chair.
If you can turn to page 45, which is,
45.
that's where you set out the purpose and objectives of the investigation and the report.
Yes, that's correct.
Yes, so can you tell us what those were?
Okay, 3.1. The purpose, that's just background information. The purpose of the report is to inform the Department of Public Enterprises regarding the background to the investigation, our approach to the investigation and procedures performed, any assumptions made and estimates applied, our factual findings in respect of the investigation, and our conclusion and recommendations based upon our factual findings. Paragraph 3.2, the primary objectives of the investigation are to establish the cause of the soured relationship between Alexkor, RMC, PSJV, and the marine contractors and make recommendations on improvements that can be made. The second bullet point, to establish whether the board and the executive of the Alexkor, RMC, PSJV exercised objective, fair, and transparent processes in the management of Alexkor, RMC, PSJV.
Now, you go to paragraph 3.3, and your title there is the focus areas of the preliminary investigation were as follows. What informed the choice of these areas as the focus areas?
Well, this was actually highlighted by the Department of Public Enterprises, and they are based on the concerns and issues raised by the marine directors to the department. Okay, so it was an attempt by the department to address their concerns as well.
And so these are the focus areas. Can you tell them what they are?
The first bullet point, to investigate the validity of the decision taken by the Alexkor RMC PSJV to exclude the 3 marine contractors in 2018 mining services procurement cycle, to investigate the procurement process in the appointment of contractors, in particular, the appointment of a diamond marketing and sales company, to investigate the process followed in the evaluation of diamonds from the mine site to the diamond marketing and sales company officers, to obtain and review the prices of diamonds realized since the appointment of a diamond marketing and sales company, to investigate the alleged failure to comply with the contractual arrangement, giving access to the information relating to sales and marketing of the diamonds to the contractors. To investigate the legality of the cofferdam operations, which allegedly have caused adverse environmental damage, to review all contracts entered into between the PSJV and the marine mining contractors, as well as any other contract forming related to the subject matter of the dispute between the parties, to determine the contract awarding processes and systems are fair, transparent, equitable, with a focus on mining contracting for both land and marine mining contracting, including the appointment of the diamond marketing and sales company. I think it's just a repeat of that. To determine the legality of the cofferdam operations, which currently undertaken at the Alexkor RMC PSJV, and make recommendations on the outcome of the investigation.
Thank you. Now, where did these focus areas emanate from? Because these are very detailed.
Again, the Department of Public Enterprises. They gave us our scope and then detailed it for us. Because what we normally do when we do an investigation as well, once we get appointed, we then have a briefing session with our principal, because we don't want misunderstandings. So we make it clear at the briefing session. They will then detail what we need to do. And this was also where we got some of the issues.
Okay, thank you. And if we move to page 49. There you set out the, are you there?
I'm confused with the numbering, but I've got it. Okay.
Yes. There you set out the approach and the procedures performed.
Yes.
Can you tell us shortly, without reading word for word, what was your approach and the procedure?
Well, essentially what we do is we have a briefing session where we would meet with the client. After that, what we do is we then agree on an implementation plan. And that's where the 3 months came in. This is what we're going to do, and our deadlines for the reporting and all that. After that, it's what we do is collation of documents. We collect all the documents, and once we've collected all the documents, so what we have here is just showing you our procedures. We collect the documents, and what documents we collected, we then review the documents, and then do, if necessary, our interviews and all that. So that's basically the approach that's used.
Now, in this case, where did the briefing take place?
The initial briefing took place at the Department of Public Enterprise, their offices. We met the officials there.
And where did you get the documents?
The documents, initially the Department of Public Enterprises was going to give us the documents. But Alexkor, the PSJV, is situated in Alexander Bay, which is very far. It was then subsequently agreed, because we were not getting the documents. We then liaised directly with the company secretary called Reagan Phillips. And she electronically emailed us documents, which we then used here. And when we did visit the Alexkor plant, we were also given documents.
So the person that gave you the documents is the company secretary of the PSJV
That's correct.
to enable you to conduct your investigation?
Pardon?
To enable you to
Yes,
conduct your
correct.
investigation? Okay, thank you. If we move ahead to page 60,
Page 60.
Yebo.
I'm on page 60.
Yes. So you say here background information on individuals and entities. You are talking about the entities that you were to investigate.
Yeah, essentially it was Alexkor, the joint venture,
Yes.
just a background information on that. And then Scarlet Sky Investments 60 Pty Limited, this is the marketing company. This is the company that was appointed to sell and market the rough diamonds. Okay, so we just gave a background. And also in the background, it's included who the individuals are, their links and so on. Okay.
Please tell us who the individuals are and what their links are as contained in your report without reading necessarily from the report.
Okay, Daniel Mark Nathan was the director of Scarlet Sky Investments, but he was also the CEO. Hazel Emmon, Moira Emmon, was what you would call a standing director, because Scarlet Sky was a shelf company, and she was the second standing director. Christian Goos was also a standing director. A lot of shelf companies would see his name. So he's also a stand-in director. Then,
A standing director being simply a director who is a director while a company is a shelf company ready to resign once they've sold the company to somebody.
yeah, that's correct, because if you have an incorporated company, you must have a director.
Yes.
So that's,
Yeah.
so
But
you,
basically at that time, the company is not doing anything.
yes, yes.
Yeah, okay.
You're right, Mr. Chair. And then you had Kasevan Govender, who became a director in 2015. And then you had Kubentharan Moodley, who was appointed at the same time that Daniel Nathan was appointed, a director. And he subsequently resigned on the 5th of November 2015.
Yes.
Okay, so those are the four directors.
And you can continue with what you were describing there? Because you were describing the parties.
If I can just read
Yes.
in 8.24, there have been allegations that Kubentharan Moodley was close to Salim Essa of Trillion. Okay, so and then we did a Google search, and then found that there was a formal search seizure in storage facility by the State Capture Commission. In the same court, Moodley had requested the court to interdict the Zondo Commission and deny them access to his documentation and other important personal items, including jewelry and cash that are in the care of Wayne Ryan Becker at his storage facility, Knox Titanium Vaults, which is in Senton. It appears that Moodley's name has been mentioned many times at the Zondo Commission. There are allegations that Moodley assisted Trillion Capital to loot Eskom and help the Guptas with 10 million to buy Optimum Mine and had a hand in the Mediosa contract in the Northwest.
So this was the case at the time that you were preparing this report?
This was the case. What we normally do as well is just to get background information on the individuals that we are dealing with so that we have a better perspective of what's happening.
What else are you saying here in relation to Moodley?
On paragraph 8.26, the available information suggests that Moodley was the former advisor of the then Mineral Resources Minister, Mosabenzi Zwane. Zwane was appointed to former President Jacob's cabinet in or about September 2015. We note that Moodley resigned from SSI, which is Scarlet Sky Investments, on 5 November 2015. This is soon after Zwane was appointed to the cabinet.
Now, just for my own sake of understanding, did Moodley become an advisor of Minister Zwane after he left, he resigned, or before he joined?
It was before he resigned. Because he resigned in November, and he was appointed in September, if I'm correct, yeah.
Oh, because you are mentioning the appointment of the minister,
Of the minister.
as having been in September. So I'm just trying to get clarity whether you are saying Moodley started, or rather became a advisor after he resigned, after Moodley resigned from SSI, or was he an advisor prior to Minister Zwane becoming a minister? Because
I don't mention
your sentence says the information suggests that Moodley was the former advisor of then minister. So I'm not sure whether is a former advisor is what you wanted to say, or when you say was a former advisor, you meant he was an advisor prior to the minister being appointed.
Okay, I'm with you. No, when Zwane was appointed, okay, Moodley was still a director of SSI. As soon as Zwane was appointed in September 2015. So why I'm saying former, it's a former now, currently speaking, it's former. So he resigned in November. Now I can't remember whether he became an advisor in September or after he had resigned, unfortunately.
No, that's fine. I just needed to understand whether he was former then or if he is former now.
It's former now.
All right, thank you very much. You mentioned another character in paragraph 8.2.7.
We found that Zarina Kellerman, a lawyer, was also one of 3 individuals appointed to advise Zwane. The 3 advisors included, in addition to Moodley and Kellerman, Malcolm Mambaso. The information in our possession suggests that Kellerman purportedly conducted a due diligence on SSI after they were appointed by the PSJV.
Okay, you can leave it there for now. We'll continue with that train of thought
Okay.
when we get to the relevant part. And on 8.2.8, you explain the structure.
Yeah, the structure was essentially Daniel Nathan Trading owned 40% of the business and was represented by Daniel Nathan. 60% was owned by Kimodi, represented by Moodley. So this gave so in terms of the black empowerment structure, there was a majority shareholding, black shareholding.
Okay. You can now turn to page 64. This is where you're dealing with the review of agreements, and you start by the deed of settlement between the Richterveld Mining Company and Alexkor and the government of the Republic of South Africa.
The deed of settlement was, it was an agreement between Alexkor on the one hand and government on the one, and also the agreement of and also the Richtersveld Mining Company. Now, the Richtersveld Mining Company was the company that was owned by the local community. Now, in 2007, the court declared the deed of settlement a court order. The deed of settlement deals with a number of issues, deals with the issue of the mining rights, environmental issues. It deals with the way in which the company will be governed. It also, there's a paragraph that stipulates that an interim joint board must be appointed. The interim joint board would then form a pooling and sharing joint venture. But also very important, because the next agreement called the unanimous resolution, the interim joint board had to formulate an interim, what they call a unanimous resolution. The unanimous resolution is, in a sense, a governance framework, because it speaks to your subcommittees, what subcommittees there should be. It also alludes to procurement issues, in a sense. So that was important, just to establish the PSJV and give it a governance framework. So the deed of settlement and the unanimous resolution should be seen, together.
And what did the unanimous resolution say?
Well, the first thing that they had to do in terms of the unanimous resolution is to form the pooling and sharing joint venture, the establishment of that. Okay.
And how do we know what were the terms?
The terms in the share, okay, just hold on. When you say the terms of the unanimous resolution.
Yes.
The deed of settlement refers to that the unanimous resolution should be formulated. So those are the terms. The terms come directly from the deed of settlement.
Mm-hmm. And it also, the deed of settlement also says how the formation of the JV is going to happen, and also to give effect to the agreement in terms of the ownership and the shareholding.
Yes. I think if you look at paragraph 9.1.9, it says here clause 8.4.5 stipulates that the members of the IJB, which is the interim joint board, must, before the unanimous resolution can take effect, refer the unanimous resolution to the principles for unconditional. So they then did the unanimous resolution, but got agreement from the principals. That is the government and Alexkor. Okay.
Yes. So this involved the government of South Africa. From the time that the joint venture was contemplated, the government was a party to that arrangement.
Yes, because they are in effect the shareholder of Alexkor, and also because they have a 51% shareholding in the joint venture. They're also a shareholder in the joint venture, pooling and sharing joint venture.
Okay. You move on and you start dealing with the agreement that was concluded by the JV and SSI. On the next page, 66.
66.
That's where you then move on to speak to that.
An agreement was signed and completed between the PSJV and SSI. SSI was appointed specifically to market, value, sell, and for the beneficiation of diamonds. Now, the agreement was signed by Daniel Nathan, representing the SSI, Scarlet Sky, and then Mervyn Carstens, who was the CEO at the time, Mr. Chair. He represented the PSJV and signed the agreement. The agreement actually stipulates what should be done. For example, it stipulates the type of pricing model that they should have. An auction sale should be conducted in order to sell. They also stipulated the way in which the diamond should be sold. They gave a breakdown. For example, 10% had to be sold to the state diamond trader for beneficiation purposes. Another 5% had to be sold to a local company, also for beneficiation purposes. And then 85% had to be sold to an auction sale. These were key elements in the agreement. Okay. And then it also speaks to the commission that has to be paid, a handling fee, which was 1.5% at that stage. Okay.
Okay. And this contract was signed in? It's in paragraph 9.3.3.
It was signed on 4th March 2015.
Yes. And then you move on the next page, you talk about a second agreement.
Yes, there was a second agreement. The first appointment was a 3-year appointment. So they were appointed at the beginning of 2015, SSI. But sometime in 2016, a new procurement process was started for the selling and marketing of the diamonds. Nobody can explain why, because the term had not expired yet. But they were appointed, so this agreement relates to that. It's essentially the same, but there are a few differences. For example, the first agreement was a 3-year duration period. The second agreement, the duration period was extended to 5 years, which was quite a long time, you know. And also there were key issues. For example, the 5% that had to be sold to the they had to be sold locally was excluded from this agreement. Okay, so essentially.
Okay. We'll go into more detail later on in your evidence as to what your findings were, because at this stage you're talking about what documents,
Okay.
contracts you reviewed. So you don't have to go into a whole lot of detail at this stage.
Okay.
But later on, you'll tell us what you discovered, yes, if you made any adverse findings and what those were and what informed that. Okay. The next agreement you looked at, you refer to on page 69. So you can tell us briefly.
Okay. This is paragraph 9.5. This is agreement to appoint the shallow water and beach marine contractors. Now, it specifically relates to, there are two differences. The shallow, there were two agreements. The one was, it's called, in fact, it's one agreement, but there are different types of marine mining. You have your beach mining activity, and then you have your shallow water activity. So it deals with those miners here. So it's just your standard clauses where, you know, what has to be, what are the obligations of the contractor on the one end, the obligations of the principal on the other end, but also the way in which payment will be done, the proceeds of the mining activity.
Okay. Now you move on page 10 to speak to about the PSJV coffer dam operations. What is a
Did you
coffer
say
dam?
page 10?
Oh, my apologies. It's on page 71 and it's item 10.
Chair was also.
Yes. My apologies. Thank you, Chair.
Coffer dam operations. The coffer dam operations, I'm not a technical person, Chair, so I'll just but I had to find out what this was. The coffer dam operations essentially take place where beach mining activity takes place. It's on the shore. So what they do is they build a coffer dam wall, and within the coffer dam wall, they would have a machine digging the gravel from this. So the coffer dam would avoid the transport of water. Now, coffer dam operations can be damaging to the environment. It depends what you are using. So the environmental management plan that the PSJV had only included the coffer dam building with sand. So, but they started using boulders and rocks to build the coffer dam. Now, once you start, that's a listed activity. In terms of the Environmental Act, it damages the environment, damages the ecosystem, and this was an issue, a contentious issue. So it was one of the issues raised by the contractors, and we looked at it. And we found that, yes, they had used boulders and rocks to build the coffer dam. According to them, they stopped using sand because the tidal waves in South Africa are very strong, and they continuously had to rebuild the dams. Be that as it may, you need special permission to use boulders and rocks. Now, they
Mr.
did
Torres?
use it.
Sorry, I just need to stop you because you keep saying they.
Oh, sorry,
So you can
the
continue.
PSJV
Yes.
continued to use boulders and rocks. They were reported to the authorities, and by their own admission, they admitted that they had used listed activity because they submitted an application called a 24G application. 24G in terms of, I think, the NEMA, the Environmental Act. Now, once you submit a 24G application, it's an admission that you've done wrong, and you want this wrong rectified. Okay, so the complaints by the contractors were valid.
And what were your findings in that regard? Because this is one of the issues that you did identify as your focus areas.
Okay. Initially they denied that they had used boulders and rocks, but I mean by their own admission, what we found was that they had then applied to the department for permission. There was a public hearing, because you need to have a public hearing, the public has to make its input. We could find no adverse comments at the public hearing about this. However, there was only one, what we found that they then received, they had to submit a new environmental management plan, which would then include the use of boulders. They had submitted that. The department didn't approve it as yet by the time that we were doing the investigation, because they were still waiting for a financial plan from the PSJV. Now, the financial plan is quite key, because when you do the rehabilitation, you need a financial plan. But what we found was that you could find no evidence that they had used boulders and rocks. And we had an interview with the executive management, and they were saying, no, we have rehabilitated the land. And that is why you won't see it there. Now, you can't just rehabilitate an environment in a vacuum. There's a process that happens. You have to inform the department, environmental department. They send out an inspector to have a look at the environment. And then at the end of the rehabilitation process, you get given a certificate to show the area has been rehabilitated. They couldn't produce any of that. You see, that in itself was illegal as well. Them just going and doing, you know. So besides the using wrong and listed activity, they also did that, Chair.
And what was the impact of what they were doing?
Well, the impact is quite serious, because once you build a coffer dam using material that you shouldn't use, you then, you know, the sea has its own self-cleansing way. So the transport, the sediments are here, the sea, the waves and all that transport the sediments. So all that was stopped. And then you find that it also damages the ecosystem there, you know, that exists. So it's quite damaging.
And as you say, it still hasn't been rehabilitated.
No.
At the time.
At the time when I was
report.
there.
Okay. Now we move on page 83 to the detail of the appointment of SSI. Page 83.
Okay.
Yes. So you conducted this investigation into the appointment of SSI, who were going to market and sell all the diamonds
Yes.
that were mined in the area by the PSJV.
That's correct.
Yes.
So you want me to? Okay, this, the first appointment of SSI, what we did was, we then reviewed the procurement process, which was very important, the manner in which they were appointed. Now, we found that the procurement the procurement process for the appointment of a service provider to sell and market the rough diamonds was ostensibly manipulated to favor Scarlet Sky. And I'll explain this, Chair. SSI was essentially a shell company when they first submitted the expression of interest. The director at that time was Hazel Emmon, who was a standing director, and the two directors, Daniel Nathan and Gobetron Moodley, were only appointed weeks later. So at the time when they submitted the expression of interest, the supporting documents misrepresented Nathan and Moodley as directors. So this was the first issue that we had. The second issue that we have, Chair, a minimum requirement for the bidder was you needed to have a license to sell rough diamonds. It's a statutory requirement in terms of the Diamond Act. Now, Scarlet Sky Investments did not have a license. So they should have been disqualified right at the beginning. And then the bid evaluation and shortlisting was outsourced to a company called Gamiro Advisory Services. Now, Gamiro Advisory Services is an external service provider. Now, the unanimous resolution does make a reference and alludes to the PFMA and the way the procurement should be run. Even though the Alexkor is a Schedule 2 entity, and the PSJV was also considered a Schedule 2, you need to formulate your own policy. It's like Transnet and ESCOM, they are all Schedule 2. You are allowed to formulate your own policy, okay? However, they did not have a policy specifically for SCM. So the Treasury prescripts applied. So in terms of the prescripts, you need to have a properly appointed BEC made up of staff members and management. You cannot have an external party doing the evaluation and a short list. You can bring them in as advisors, Chair, or technical advisors, because there are some technical issues. So this was an irregularity that we uncovered. Okay.
The non-compliance by SSI with one of the minimum requirements, namely being in possession of a license, that could not have been an oversight on the part of those who were supposed to disqualify them.
Yes, it could not have been, because it's one of the main requirements.
Because the first thing you do is, do they meet the minimum requirements? Now, in your investigation, did you confront the person who was supposed to establish whether SSI met this requirement? And if you confronted them, what was their explanation?
Chair, firstly, Gamiro Advisory Services, who did the evaluation, actually allocated 0 points to Scarlet Sky for not having a license.
Okay.
Okay. So, I mean, this was disregarded by the tender committee.
So it's the tender committee that was supposed to pick this up?
Yes.
Or at least they should have given effect to the 0.
Yes, they should have, and they didn't give them 0.
Yes.
They gave them the full 5 points. And so this is where the discrepancies came about.
Yes, but what I'm asking is whether you were able, as the investigators, to confront the tender committee, the chairperson or whoever, to say, how could you
Okay, Chair,
not have disqualified SSI? What's your explanation for this?
These were former board members, and we were unable to contact them. So we didn't confront them. But we did speak to the executive management team and to understand why this happened.
Yes.
Okay. So, but they also were excluded from the process, and they couldn't.
You know, there is a tendency sometimes with investigators that just because somebody is no longer employed by the entity, then they don't follow them. Why couldn't you get hold of them? You couldn't get hold of even one member of the tender committee, former member, to say, tell us what's your explanation, or send them a letter saying, we are investigating, we have been mandated to investigate, and this is what seems to have happened here, and you were part of the tender committee, and it seems you should have picked this up, and you didn't disqualify this. What's your explanation for that? Because we may make an adverse finding about you and the tender committee. What's your explanation? Give us your explanation by such and such a date.
No, we didn't, Chair. We also had tight deadlines and time constraints. They wanted the report. So, I mean, there were a number of other issues that we wanted to follow up, but unfortunately couldn't.
Well, it's a pity you didn't do that because, I mean, you did have 3 months, and if necessary, you could have told the Department of Public Enterprises that you needed more time because this is quite crucial. Because you have a situation where your investigations reveal that members of the tender committee failed to disqualify an entity that should obviously have been disqualified. You need an explanation why they failed to do that, because they could not have not seen that the SSI did not have a license, because their job would have been to find out, do you meet these minimum requirements? Did they ask that question? And what was the answer? Because it may mean that they were part of corruption. And that's quite something serious. And you don't want to reach that conclusion without giving those people an opportunity to give an explanation for their strange conduct. You understand that? And it enriches your report if you have confronted those people and you are able to say in your report, after we picked this up, we approached the tender committee and asked them, gave them an opportunity to explain. And this is the explanation they've given. We think this explanation is nonsense, or they failed to give an explanation, and we think they failed to give it because they have none. You understand that? Then your report has more value than if you leave them out.
Chair, could I say something? Thank you, Chair.
Okay, all right.
I hear what you are saying. I think the next point that I was going to raise, Chair, was the tender committee recommended the appointment of Scarlet Sky. However, they gave a condition. They said, we will recommend the appointment provided a due diligence is conducted by the CEO, Carstens, who was also on the board. Now, Carstens then informed the board that he had conducted the due diligence. A due diligence would have entailed also confirming the legality of the license, okay? Now, Carstens misrepresented to the board that he had conducted the due diligence. And on that basis, they were appointed. So we had interviewed Carstens about the due diligence. He says he's done it. However, the company secretary informed us that no due diligence was done. And he wrote an email saying that he has done the due diligence. So we looked at it from that point of view as well.
But if you have done a due diligence, wouldn't there be a report?
Yes, there should be, because we want to know what you've...
Yeah, and if he said he did it, did you ask for the report? Where is your report?
Yes, we asked. For months we asked the report repeatedly. They had to eventually admit that no due diligence was done.
He ultimately admitted.
Well, no, the company secretary.
Yes.
Because he still admitted.
Yes.
He still maintained that he had done a due diligence.
Yes. Okay, all right.
Thank you, Chair. I think it's an opportune moment.
Yes, let's take we'll take the T adjournment. It will be important that I hope the commission investigators have closed the gaps that I'm talking about, that there will be evidence to say the tender committee has been approached about why it did not disqualify SSI. Do we have their affidavits? Do we have an explanation? What is the explanation? Matters like that. There may be other minimum requirements that were not met. I hope that's been taken care of.
Indeed, it has.
Yeah.
Thank you,
Okay.
Chair.
We'll take the T adjournment and we will resume at 22:12. We adjourn.
All rise.
which, as I understand from what you are saying, were full points, knew that there was no license, and therefore in awarding the full points must have been acting fraudulently, because they would not have seen the license, isn't it? Or do I misunderstand something?
No, I agree with you, Chair. There was no license.
Because you can't, either the entity has a license or it doesn't have. It can't be given 60% of the 100 points, because if you have it, it's full points. If you don't have it, it's no points, 0. And therefore, if you award full points without there having been a license, then that must be fraudulent.
Yes, there was no license, Chair. And they should have, and this was one of the discrepancies we find. That's why we did the comparison.
Yes.
And I agree with you.
Yeah, because you can't say we'll give you full points for a license when you haven't seen the license.
Correct.
Yeah. Or at least haven't satisfied yourself that there is a
There is
license.
proof of license, yes.
Yeah, and I guess the way to satisfy yourself is for you to ask the entity to produce the license.
And Chair, we did, if I can say, we did approach the diamond regulator, and the diamond regulator confirmed that
Yes.
SSI does not have a license.
Yes. So that 5 points is most likely fraudulent,
Yes.
the awarding of that. Unless those who awarded come and give an explanation that we can't think of. Yeah, okay.
They have been invited, Chair, to come and give their explanation. We are hoping that they will.
Also, Chair, we found that in the original bid submission, Scarlet Sky Investments had proposed an outright purchasing model. All other bidders had proposed the auction sale pricing model. Now, the outright purchase price pricing model was what was used by the previous service provider. And this caused so much unhappiness. It was a contentious issue. It was actually anathema to management and the contractors. So when they did their presentations to the tender committee, it was changed to the auction sale pricing model. Now you have a bid validity period of 90 days. Within that bid validity period, you can't make changes to the bid. Or if you do make changes, all other bidders must be informed. The company secretary again informed us that they had not informed any bidders that changes were made. Now, allowing SSI to make a crucial change to the bid submission is an unfair and uncompetitive practice. And it is a contravention of the Constitution, Section 217. So we also found this to be a problem. And then lastly, it's the due diligence issue, which I alluded to earlier, that was not conducted. Okay? So in essence, the procurement process was irregular. It appeared to be manipulated to favor SSI, given that all these discrepancies we found.
So you are saying whether we were looking at the license issue or we were looking at the other issues?
Yeah, the license issue was one issue, but there were a number of other, all these issues taken into account shows that there was a manipulation taking.
But of course, the license requirement is a crucial one, because you shouldn't go beyond that stage if you don't have it, because how are you going to do the job?
Correct. Yeah. No, I agree with you, it's a crucial issue.
Somebody as a driver if they don't have a driver's license?
No, you can't do that.
Okay, all right.
Thank you. Now, Mr. Torres, and with your leave, Chair, you are aware that Gamiro have prepared a response to these issues, yes?
Yes, I've been informed.
Yes. And you are aware that according to Gamiro, they were not instructed to shortlist and they did not shortlist. Can I refer you to page 622?
Is that in the same bundle?
In the same bundle, Chair. It's not the affidavit.
622.
Yes, yes, Chair.
Okay.
Am I correct?
No, a letter,
No, sorry, I'm waiting for the chair to get to the page.
I am here.
Am I correct that this is the document on which you base your conclusion that they were the ones that shortlisted?
Yes,
And-
this is the document, the letter of appointment.
Yes, and this document that we find on page 622, tell us what it is and just read it for us.
Okay, this is a letter to the Chief Executive of Gamiro Advisory Services, and it's the appointment letter to Gamiro to evaluate and shortlist the procurement process for the marketing and selling of rough diamonds. And the letter has been signed by Mervyn Carstens, the Chief Executive Officer.
Where did you get this letter?
This is a letter that we got from, in our batch, because we got batch documents from, the company secretary was our main liaison. So she sent us all of these documents. So we got this in our batch from the company secretary.
The company secretary of the PSJV.
Of the PSJV called Reagan Phillips.
So she is the one that when sending you documents that would support the investigation that you were undertaking, included this document.
Yes. What we would also do is we would give her specific documents that we wanted and say we need these documents, and they would send it to us.
What was the point, Ms. Sibia, about the letter that you say somebody, is it Gamiro or somebody makes?
The affidavit that has been submitted by Gamiro but was submitted in short notice and therefore is not yet before the chairperson, in that affidavit they dispute that they were instructed to shortlist. Yes, and
Do they
the-
do so on the basis of this letter?
They say that they never received this letter, and I'm taking Mr. Yes.
okay, all right.
Yes. So they dispute that they shortlisted in the first place, and Mr. Torres has just given evidence of the scoring and the fact that they shortlisted. So
Is that a way of saying they were not required to check whether somebody had, the entity had a license?
no, they say that they scored them 0 for that aspect.
Oh,
But
okay.
they are distancing themselves from having ensured that
But
SSI is,
giving them 0 for that aspect should mean they shouldn't proceed to do anything else.
Chair, I don't want to be
You don't want
giving
to be their
evidence.
advocate.
Yes, however, what they say in their affidavit, which
Yeah.
is under oath and they have submitted, is that they only put in the scores, but did not say these are the companies that must be shortlisted. They say they did not have the authority
Okay.
to disqualify.
I'm sure they'll come and explain.
Yes,
Yeah, okay. But it's important for you to put to Mr. Torres what they say about
yes,
their report, yeah.
yes. So do you accept that they did not?
Well, based on this letter, they did do a short listing. And at any rate, when you do the scoring, it's also an automatic shortlisting process, unless, of course, you say a company must be disqualified, and you state it explicitly why. And their scoring already was the shortlisting.
And surely, by employing Gamiro, they expected them to perform a certain, they had to have a certain expertise.
Yes, because you don't employ an external service provider if they don't have the skills and the capabilities to do the job, because we have the skills in-house. So yes, they should have known that SSI had to be disqualified for not having a license.
How many tenders were in fact received?
There were 7 tenders that were reviewed, Chair. There were actually 9 expression of interest submitted, but 2 did not attend the briefing session and did not submit a formal proposal.
So there was an external service provider appointed to evaluate 7 tenders?
7 tenders, correct.
And in your view and in your...
That is the bids, seven bids for a particular tender.
Yes,
Yeah.
for a particular.
Okay.
So in your view, why would they have needed to appoint a service provider for the evaluation of the 7 tenders, if not to shortlist and not to...
Yes, you're quite right, because you have the expertise inside. We have been doing this job for quite some time. And they do the bid evaluation all the time. And then you appoint an external provider. It raises the question, why specifically this service provider? And why were they asked to shortlist? Because normally you just say, do the bid evaluation. The bid evaluation should in itself tell you who goes to the next level. Have they reached the threshold level? Because there could have been a threshold level. I think there was a threshold level, functionality level of 70. So if you don't reach 70, you don't go to the next level. Okay. So you don't. So there must have been a reason. Why?
Were you given an explanation why this was outsourced during your investigation?
What we wanted to know, why, we also found that the company secretary and the other executive members, because they were not involved, could not give us an explanation. So we then asked
But somebody must have taken the decision to outsource. Did you
it was
approach that
Carstens.
person?
Carstens. Now, there were allegations that he had previously, in his previous job, had contact with Gamiro Advisory, but we could never confirm it.
Yes, but what I'm asking is, did you confront him to say, explain why it was justified to outsource this? And did you approach him? Did you provide an explanation? If he did, what was the explanation?
Well, all that he said was they have the necessary expertise and knowledge to do this particular job. And also that they were doing other advisory services for the entity.
I'm sorry, so you did approach him?
Yes, we had an interview with him,
Yes.
a formal interview.
Yes, and his explanation was?
Well, all he said, they have the expertise. They wanted them because they have the expertise.
About the internal expertise. Why not use the internal expertise?
Well,
That's an obvious question you would ask him. Why are you outsourcing? Because we have got the expertise.
well, we questioned because we said by employing external service providers, even if they have the, it's actually fruitless and wasteful expenditure. Because you have
Yes,
the
that's why I'm saying it's an obvious question for you to ask, to say,
no.
why are you outsourcing? You have got the expertise. Because the outsourcing, in circumstances where there is in-house expertise, may be an indication of something else. So it's a crucial question and an explanation for that, why it was done in circumstances where there was in-house expertise to do the job, is quite important.
No, I mean, this explanation was that they have the technical ability in terms of the industry as well, and that is why they were appointed, and we left it at there, Chair.
And what did you make of that explanation?
It didn't make sense to us, Chair, because the only technical issue was the license. The rest was, have you met the requirements? The scoring was on issues such as, okay, there was some technical issues, but the scoring was on the criteria was mainly on local development. What are they going to do on that? The pricing model was an important issue. So they could have had, and this is what our argument was. We said, yes, fine. Maybe they could have come in as a technical advisor, because that's what happens all the time. Your BEC don't have all the technical knowledge at times. So why did you not bring them in? He said, no, they were there to do the bid evaluation.
Thank you. And what else did you discover had been done wrong in the procurement process?
In the procurement process?
Yes.
Well, I think I've covered most of the items that were done wrong. It's just to summarize, there was no license. Gamiro as an external service provider, there was no compliance in the way they were appointed, because they should have appointed internal staff or have a properly constituted bid evaluation committee. Also, the scoring of the three shortlisted service providers. There were discrepancies. For example, basic discrepancies like all three service providers had, okay, after the changed bid submission of SSI, they all proposed a commission of 1.5%. But two of the service providers were given 3 points and the other one was given 4 points, for the same. So it was just, to us, we got the impression, that's why we say we think it was manipulated. They were just giving points to ensure that SSI got the highest points. That was the presentation, after the presentation.
And of course, we have the issue of the due diligence. That was a condition.
Yeah, it was a condition that I think also the subcommittee wanted to protect itself. They had made a recommendation. They then said, based on our recommendation, no, we recommend SSI. However, you need to conduct a due diligence, which was never conducted.
And
That's it.
and when it came to the board and reporting to the board about the due diligence, what
Well,
did you find?
Mervyn Carstens, the CEO, actually wrote an email to board members confirming that he had conducted the due diligence. And based on that, they accepted it and awarded the contract to SSI.
But how could the board just accept his word? One would have expected that they would ask for the report, due diligence report, so that they could evaluate it themselves, see what it says.
Chair, right from the beginning of our investigation, the due diligence report was one of the things that we continuously asked them for. Eventually, right at the end, they confessed and said, the company secretary, actually, Reagan Phillips, confessed and said that no due diligence was done.
Yes. So the letter that Mr. Carstens wrote to the board, did it say, I've conducted due diligence and this is the outcome thereof, or what did it say?
I'm trying to remember the email. It's such a long. But the email said, I've conducted the due diligence.
Yes.
The email did not specify, what was in the due diligence.
Would that email be part of the annexures to your report?
It should be.
Or you're not sure?
I'm not sure.
Okay, that can be checked later. You see, it becomes important because we also need to look at the role of boards of these SOEs. How can you simply be told a due diligence has been conducted and you make a decision without seeing the due diligence report? How do you do that?
Correct.
And it turns out there was no due diligence that was done anyway. the question arises, why was there nobody among the board members who said, where is the due diligence report? We want to see it before we make a decision. You see. Did you have access to the minutes of the board meeting where they discussed and made the decision?
Chair would have had, I think, the appointment of where the appointment was made in the board. I'm sure we've got those minutes.
Yeah, okay, all right. It would be important to see what was said, yeah. Okay.
Thank you. And then we move on to the second appointment. But before we get there, what did you find in relation to the expertise, the scoring for the expertise? Did you have any problem
The scoring?
in relation to the experience and the expertise? Did you have any problem with that?
The experience.
Yes.
SSI.
Of SSI. Of SSI, yes.
Well, I think right at the beginning, I alluded to the fact that it was a shell company. So there was no business track record, there was no experience.
Yes.
So they should have got very little.
Yes.
But there were allocated points, and then there were also gaps in their bid. That is why the criteria was changed as well, because the pricing model, they didn't have in their first budget. And then there was also beneficiation, the local community. They needed to, there was an aspect where the local community had to be empowered. That was actually removed from the criteria during the presentation stage.
Thank you. Okay, now we can move to the second appointment of SSI.
The second appointment of,
What page is that?
It's the very next page, Chair, on page 92. Maybe, I'm sorry, I
When
didn't
you
take
took
you.
us to page 622, is it 623 or
I'm
are we going
walking,
back?
I'm walking by myself, Chair, and leaving everyone behind.
Yeah, we can see that.
Yes, we are actually
You
back.
need us.
We are back at page 92.
92.
Yes, thank you, Chair.
okay, I've got it here.
Yes.
The second appointment of SSI,
Firstly, I'm sorry to cut you, Mr. Torres. Were you happy with the appointment, or did you also make adverse findings in relation to this appointment?
in our view, the procurement process for the appointment of the service provider to market and sell the rough diamonds was fatally flawed. And we did have adverse findings.
Okay, you are talking about this second tender?
Here's the second tender.
Yes. Now you can go ahead and say what your findings were.
Now, the second tender, the BEC, there was a BEC appointed, and the BEC comprised the executive management team members. So there was a BEC. We then requested the minutes, the scoring of the BEC. It was at this stage when the company secretary, who was also a member of the BEC, admitted to us that they did no evaluation at all. Their only job was to ensure that there's compliance with the requirements. Now, this is the requirements such as, is there a tender certificate? Is there a BE certificate? Now, this is an administrative job that is usually done by supply chain management staff. It should not be done by the executive team. So the BEC in itself was, we could say, a hoax in a sense, because they were appointed, but to do what? Because your responsibility as a BEC is to do evaluations. So they did no evaluation, and that to us was a problem. Already, right from the start, there were problems with the procurement process.
Did the company's admission, was the company's admission that no evaluation was done in writing?
Well, what she did was that they had no records that an evaluation had been done. And that is why it was a problem even to get minutes, documents. In fact, there was even a problem in us finding out the number of submissions admitted.
Yes, but my question is whether whatever he said, whether that was in writing, namely whether he said there was no evaluation done or whether he said there were no records indicating that evaluations were done. What he told you, was it in writing? Did he sign a statement or do an affidavit? Did he send a letter? Or was it just verbal?
No, we had an interview with her.
Yes.
In this particular, on a number of other issues.
Yes.
I'm just trying to recall, Chair, but we did, on this particular issue, it says that normally when they get appointed as BEC, they do evaluations. But I can't recall whether she informed us whether it was an instruction. And I think that is what you want to know, am I right, Chair? That she was instructed
Yes.
not to do an evaluation.
Would your interview with him have been recorded by any chance?
No.
It would not have been recorded because it's quite important information. So I would have imagined that if you did not record the interview, you would have asked him to do an affidavit or at least minimum a statement to say, give us a statement that tells us exactly what you have just told us in this interview. Did you do that?
No, we didn't.
Why not? It's such an important thing.
Chair,
I mean, evaluation was important. It should have been done. Here is the company secretary either telling you no evaluation was done, or we were instructed not to do it, or there are simply no records indicating that this was done. So now you are conducting an important investigation. How do you not secure either a statement or an affidavit from this person giving you this information?
Chair, I can't recall us asking for an affidavit, but I agree with you, it's an important point. Again, Chair, under the circumstances, in fact, we thought we'd get a second opportunity to continue and close the gaps, but we never got to a second appointment.
Yeah, it's unsatisfactory. It's unsatisfactory. I mean, this is very important. Now, somebody tells you very important information, you are investigating, you are going to compile a report, give it to the Department of Public Enterprises, and he tells you crucial information, you don't ensure that it's in writing, to say the least, or it's an affidavit, or it's recorded. It's unsatisfactory. Ms. Bia, continue.
Thank you. Maybe if I can assist you, Mr. Torres, on page 146. 146. This is the section where you detail the content of the interview. You detail the date of the interview with Ms. Phillips, and you set out in the report still what she informed you. Are you with me on page 146?
Yes, I am.
Okay. So you'll see that in paragraph 17.5.4, you say, on 4 October 2019, we interviewed Ms. Reagan Phillips, the company secretary of the PSJV, and she informed us that she's an admitted attorney who's done postgraduate studies at Stellenbosch University. And then 3 bullet points down.
Okay.
Can you see what you wrote there as a recorder of your consultation?
Okay.
Can you read that for us? So the 4th bullet point.
It's the 4th bullet point.
Yes.
Yeah. Appointed as, this is the interview with Phillips. Phillips informed as follows. appointed as part of the BEC for the procurement process involving the tender for marketing and selling of rough diamonds. The committee did not do any scoring for the evaluation purposes, only checked compliance to the minimum requirements.
Did you ask her why the evaluation was not done, or the scoring for evaluation purposes was not done?
Chair, I think I don't see it here. I can't recall.
But it's such an obvious question to ask if you are investigating. And this is what, company secretary?
Yeah, the company secretary.
Is an important official in the company, and if I recall correctly, part of their job is to ensure compliance with legislation and so on. So she sits on a committee which was supposed to conduct an evaluation, and she tells you they didn't do the evaluation, because if they didn't score, that means they didn't do the evaluation. Most obvious question to ask is, why not? That's what you were about as a committee. That was your job. Why didn't you do the job?
In fact, we raised the question that the BEC, that's their job. As you said, that's all they did. They were not given any other information to work on.
Yeah, did you ask her why were you not given? Who was supposed to give information? Why were you not given information?
Chair, the questions, we raised a number of questions. I must admit that at times they were evasive, you know, and because we also had time constraints. We were in Cape Town. We had to conduct, unfortunately, we were in Port Nolloth when there was a dust storm, and we could not conduct any interviews. So we had to reschedule because it's quite a drive to Uppington, because you have to drive to Uppington, 700 km, then get a flight back to Joburg. So it's an issue to get there. So I think the time constraints were also.
Yeah, but you had 3 months to do this, and you are interviewing the company secretary. And she tells you, I was part of the committee that was supposed to do an evaluation. We didn't do an evaluation. Obviously, you must probe further to find out why. Why didn't you do your job as a committee? To find out whether they were instructed by anybody not to do the job. If they were instructed, who instructed them? Why did they comply with that instruction? Was that instruction lawful? And so, or were they part of a certain agenda, or were they not part of an agenda? And you can't get an answer to those questions if you don't ask the relevant questions. You see, it dilutes the significance of your report if you don't ask questions that should have been asked.
I agree, Chair.
I see here on the 4th bullet point, it says, you recorded that she said they only checked compliance to the minimum requirements. Is that right?
That's right, and I do say.
And did she say that they found that there was compliance with the minimum requirements? Did she tell you that? Or what did she say was their finding about?
There was compliance to the minimum requirements.
Sorry?
There was compliance to the minimum requirements.
Yes. Is that because Scarlett now did have a license or what?
Well, they were using the license of a related company.
Is that allowed?
It's not allowed. I mean, you must have your own license.
So why did you not make an issue on that? Why didn't you raise that with her to say? Well, but if Scarlett didn't have a license, then they didn't meet the requirements. They couldn't use somebody else's license.
Chair, I hear what you say, But it says the requirements that they were given, all the requirements were met. Now, we don't have a written document stipulating what requirements were put down.
Did you ask for them?
Oh, yeah, but there was no, we asked for all of that. There were no
But
documents available.
who would have decided on the requirements?
Well, there are essentially, when you submit, there are certain requirements that you
Yes,
need. You know,
yes.
like your birth, your tax certificate, your BE certificate.
Yes,
The birth document must be properly signed.
yes,
Those
but I'm
basic
saying
issues.
somebody within the company would say, for this tender, these are going to be the minimum requirements, isn't it?
No, there was no document stipulating what were the minimum requirements.
Yeah, so how did they know what the minimum requirements are that she is talking about here?
Well, we assumed that it was just the normal administrative requirements. You know, having a tender, a tax clearance certificate, a BE certificate, submission of documents.
Yeah, but how could you assume? This is something you are supposed to satisfy yourself about. If you are asked to investigate whether a company was awarded a particular contract lawfully, obviously you go back to the start to say, okay, when the request for proposals was issued, what requirements were there? Who was eligible to make a proposal? Did this company meet those requirements and take it from there?
Well, Chair, at this stage already we knew it's a sham because there were no documents available. Because normally, even the supply chain, they would have a document like your tender requirements, where these are the requirements, and it's a tick exercise, really. You're quite right, Chair, it's a tick exercise. But there was nothing.
But does your report say that there were
Yes,
no
there
such
were no
documents?
We asked for it. It does say
It does say that.
that we asked for all the minutes and everything. And
But are you saying at page 146 of the report that Ms. Phillips said they checked compliance with the minimum requirements and found that there was compliance? Is that what you record her as having said?
I said only check compliance to minimum requirements.
Yes.
And
So what I'm asking, what that means, because it says only checked. Now, you can check and find that there was no compliance with the minimum requirements. You can check and find that there was compliance. So this doesn't tell me which one. So I'm asking you, did she say they checked as the committee whether there had been compliance with the minimum requirements and found that there had been compliance with the minimum requirements? Or
Yes,
do you
this-
not remember?
yes, there was compliance, but we needed also the documents, and that was not available.
Yes.
Because to us that, it's again, yes, there was compliance. What did you check? They couldn't give us. And I think this is one of our requirements that we wanted, the compliance checklist, which also we didn't get.
But your report in regard to your interview of her doesn't, unless it's dealt with elsewhere, doesn't reveal that you raised these queries, unless you deal with that somewhere else. Because you are interviewing the company secretary. She says we checked compliance with the minimum requirements, and obviously you have to say, what did you find? If she said there was compliance, you say, what were the minimum requirements? Where are the documents that say those were the minimum requirements? That doesn't appear in the
It does not
report.
appear yet.
And yet it's quite something important, because how can she say there was compliance if she can't produce the document that tells you what those requirements were? Can you see where my problem is?
No, I hear you and I agree.
And you were I would have expected you to want to satisfy yourself on this because you want to be able in your report to say, was she right in saying there was compliance with the minimum requirements or not? You see. In your report, did you deal with whether she was right about that?
the BEC, I only deal with the BEC issue and what she responded to. The focus was because after there was a short listing done. And the short listing, they also again, like the first procurement, presented to the tender committee. Okay. Now, also again, our problem was, how did they shortlist if there was no evaluation done? There was no documents, nothing. In fact, the procurement process for the second appointment was a sham.
Yeah, but you, at least this page 146 doesn't reflect that you probed issues that you were supposed to probe. She seems to tell you she checked compliance with the minimum requirements, and that seems to be left at that.
Yeah. Chair, I think if you look at the issues, 3 months might seem a long time, but it's a short time with investigation.
Yes, but just this one person, you don't need, I mean, just an hour with this person, you say, okay, what were the minimum requirements? And
Well,
you say, these were the minimum requirements. Where are you basing that on? Where is the document that told the bidders these were the requirements? Where do you get that from? How can you say there was compliance if the bidders were not told what the requirements were?
Chair also must understand that this also served as a preliminary investigation. We had expected to then have another phase where we would probe certain aspects.
Yes, but these are the basic minimums. Why must those be dealt with by another investigation? These are the first things you look at, and then they don't need a lot of time. You see, why must the Department of Public Enterprises have to either appoint you or appoint somebody else to do another investigation after they have paid whatever they paid for your report, when this can be established very quickly? Okay, Ms. Bia, continue.
Mr. Torres, on page 92, you set out on 12.1.2 what were the minimum requirements. On
What page?
92, Chair. In paragraph 12.1.2.
No, on 92.
Yes.
Oh, I'm looking,
92
sorry,
in
I'm
black.
looking here. The wrong page.
12.1.2, Chair.
Okay.
You set out the minimum requirements for this second bid. And
12.1.2 doesn't set out the minimum requirements. It sets out what was considered to be minimum requirements. I don't know considered by whom.
well, Chair, I'm still taking Mr. Torres to the document that supports, because I think some of it he might have forgotten, but he makes reference to
Yeah,
it.
okay.
Yes. So, if I can take you very, very far to page 640 of the same document. (640). In fact, that identifies the number of the exhibit only. Now, the document that appears there, it's called the tender. It says marketing. Oh, you're not there yet. Are you not there yet?
Pardon?
You're not there yet.
I am, it's 642, you say?
Yes, 641.
641.
Yes.
Yes, I am there.
So what is this document?
It says the marketing, post-extraction treatment, processing and beneficiation of diamonds.
Yes, but what is this document?
Pardon?
What is this document?
It's a request for proposals.
Okay. And it's the request for proposals for the same contract we are talking about?
That's correct.
Okay. Now, if I can take you to page 655 of that same document.
Yes.
Do you see in the middle of the page where it's in bold? 655.
Oh, 655.
Yes.
I've got it.
Can you see in the middle of the page? This is still the same document. Can you confirm that it's still the same document that we've just identified?
That's correct.
Okay. Can you see the heading in bold that says Section 2, detailed terms of reference? In bold in the middle of the page.
Yes, I do see it.
Okay. Can you see that subparagraph? And immediately below that it says, as a minimum requirement, proposals must demonstrate the bidder's ability to.
Okay, I'm there.
Okay. Do you not think this is where you got the minimum requirements?
I think
That you
because
reflect-
It's exactly the same as the report. Almost.
Yes, it is almost, it's not everything. It's this document, the items listed on this page, there's only 4 of them, so it's A to D, and then you on page 92, in addition to what they have put in, you include a BEE level and you include the tax clearance. But in terms of the substance, this is exactly the
This is
same.
Yes.
So
Well, what was the page on the other one which has got considered?
92,
92.
yes. We can go line by line.
So now, Mr. Torres, how does your evidence that there were no documents setting out the minimum requirements
Well,
gets reconciled with this document that sets out at page 655 the minimum requirements?
no, I've got the minimum requirements, but I think I'm talking about the compliance check. There was no documents showing which compliance check was done. Because
Well,
we needed the minutes.
you and I were talking about, you remember the page in your report where you recorded what the company secretary said in the interview you had with her. And she had said, according to that report, only checked compliance with minimum requirements. And then I asked the question, was there compliance? Did she say there was compliance with the minimum requirements? Because checking compliance with minimum requirements doesn't tell me whether there was compliance or there was no compliance. So we then got to talking about what were the minimum requirements. That's when you said no documents were provided to you that set out what the minimum requirements, as I understood your evidence.
Based on the report, there were, the minimum requirements were there, Chair.
Sorry?
Based on the report, the minimum requirements were there.
Yeah, no, I now know that they were there, but I understood you to say you asked for documents that set out the minimum requirements and you were not provided with them. That's how I understood your evidence. Did I misunderstand your evidence?
Well, we did ask for documents that were not given, the minutes, even the compliance check, because she must have signed the compliance checklist to say that I've done this list and this is, that we didn't get. But the compliance, the minimum requirements as specified in the terms of reference, it's part of our exhibit, annexes.
Ms. Sibia, how long do you need with this witness?
Chair, I think 1 hour. Yes, Chair. I don't want to underestimate the time as we are known to do.
Well, we still have about 30 minutes before we get to 1 o'clock. See how much you use that 30 minutes. I'm not sure that we need an hour. Continue.
Thank you, Chair. Thank you. Now we move on to the issue of the marine contractors.
Okay.
If I understand correctly, these were the people that had complained to the DPE, and this related to the same soured relationship that had been identified and had been part of the reason that you were appointed to conduct this investigation. I'm taking you to page 98.
98?
Yes.
I'm there. Yeah.
Okay, yes. So, what did you investigate and what did you find, as briefly as you can? What was the complaint that you were investigating?
On the evaluation process itself, we found no adverse findings. There was a properly constituted BEC, also made up of the executive team. So there were no issues with that. There was the BEC stroke tender committee recommended 8 out of the 19 bids. There were 2 bids, the beach mining activity, and there was the shallow water activity, marine activity. So the beach mining activity, there were 19 submissions. 8 bids were recommended for award. The shallow water marine tender, there were 66 bids submitted. 51 bids were recommended for appointment. Included in the 51 bids, you had 4 contractors that were subsequently excluded from the procurement process by the board. Okay. Now, the board held, and the 4 contractors that were excluded were Ocean Diggers, Malakaza, PL Marine, and Repsol. These were the 4 contractors. Now, this is all related to the relationship that existed between the contractors on the one end, the executive management and board on the one end. It was a hostile and unfriendly relationship. And the board then decided, they had a special meeting held where they discussed the appointment of these 4 contractors. At this meeting, the board decided to exclude them from the procurement process on the basis that they were disruptive, they were abusive, they had damaged the reputation of the board and the executive management. So on this basis, they were excluded. However, the process was not followed. Even because in terms of the unanimous resolution, it's quite explicit. It says the executive management can recommend to the board the appointment of an independent contractor. If the board disagrees and rejects the recommendation, it must be referred back to the executive management for reconsideration. The executive management then referred the matter back to the board. And if the board can't refuse or reject, the second time around they can't reject the recommendation of the executive team, provided that the organization will be financially prejudiced. Now, the exclusion was not based on financial prejudice. It was because of the type of relationship that existed. So the board acted improperly in rejecting the award of the 4 contractors.
Mr. B, I remember that his report is before me, and
Yes.
their findings are there, whatever recommendations are there. I think what's more important for you to look at the important findings that you want to bring to my attention, let him deal with them and the basis for those findings and take it from there. Otherwise, most of what he says is in the report and one can read it, but it's important to see the basis for certain
Yes.
findings.
Yes.
Yeah, and question him on the basis or the process of conducting the investigation.
Thank you, Chair. I'll do so. Now, Chair, this is not an indication that I'm not following what the Chair has said, but I'm just going to move to the next page.
No,
of
that's
the-
fine.
of the report, because it's the next topic.
That's fine, yeah.
Thank you, Chair. On page 108, it could be that I'm saying it's the next page and maybe I've left you behind again. But I'm now asking us to go to page 108.
108.
Yes,
Okay.
That 108.
yes, 108. Now, this was one of the more contentious issues, am I correct?
Yes, it was a the valuation and pricing were contentious issues.
Yes. Okay. Tell us what you were asked to check and the process that you followed before you reached your finding,
Okay.
as briefly as you can.
There were complaints that there was, Chair, there were complaints that the diamonds were being undervalued and that no proper valuation process was being done. Now, the way they value the diamonds, they call it the 4 C's method. It's your carat, your color, the clarity, and the cut. Now, there was a problem. There are 2 valuations done. At the processing plant, they have the PSJV. They've got a diamond valuator who then do the valuation there. Now, the valuation being done by the PSJ valuator was done purely using carat quantities. The other C's were not used. And we inquired why. And according to Customs, who was the CEO, he said no, she has gone, the evaluator at that stage had no skills. She could only do carat valuation. So that was the reason they gave. And then there's another valuation done by SSI. They get an independent valuator to do a valuation. There were also complaints about the valuation done by SSI. What we did with SSI, we then requested them to give us the certificate of valuation. Because each diamond there's a certificate issued. Because that would give us more details on how it was done, what carat was there, the cut, the clarity and all that. They could not give us any certificates. I mean, they promised, but they never gave us. And then we also did a comparison because it was very difficult now to do the valuation based on, because they didn't give us any information. So we were forced to then do a pricing, to get the pricing index, the Minsky pricing index, and also the second index was Bloomberg. Now, it's not ideal to use this index because the pricing is averaged and a mixed bag of diamonds get used. So your pricing would also be lower. However, we found that there were big discrepancies, that the pricing was much lower than the Bloomberg and the Zimnisky prices. And in fact, undervaluation, so there was a big problem there with the valuation. And then, of course, also, there was no compliance with the contractual terms of the agreement. Contractual terms are very clear that 5% of the diamonds must be sold to a local buyer for beneficiation purposes. The 10% must be sold to the state diamond trader in terms of the Diamond Act. And then the 85% had to be purchased by buyers through an auction sale. Now, when we looked at the after-sales report and the invoices, we found that, firstly, it depicted that 85% of the diamonds were being sold to Scarlet Sky. And in terms of the contract, it should be through an auction process. We then requested the names of the bidders because they insisted that they hold auctions. So we said, okay, then why? You should not be putting your name on the after-sales report. The response was, it's classified information and we can't reveal it. We then insisted that, no, PSJV is your client. It's their information, right? And we're doing the investigation. They said that we never got that information because we needed to know who are the buyers. We also needed to know how much was sold and to which buyer. It's very important. So that was a big problem to us. So that is why we were also forced to do the Zimnisky Bloomberg valuation. We then found that when we looked at the 10% and the 5% sold, we found that it was based on carats, carat quantities. Now, in terms of the contract, it should be based on value and not on carat quantities. So we did a comparison, and then we found that the way they did the pricing, they actually undersold to the state diamond trader by 60 million. And they also undersold the 5% locally by 38 million. There was a dispute with them all the time because they insisted it's done on carats and quantities and we are misreading the contract. And even the regulator agreed with us it should be on sales value. And the Act says as well, because it's a statutory requirement that 10% gets sold, it's on sales value. So there was definitely, it was a means of selling poor quality diamonds to locally. Okay.
Mr. Torres, when you speak about the 60 million amount,
Yes.
that was the value of the undersales, over what period?
We're talking about since their first appointment, which was the beginning of 2015, right up to the time that we were appointed, I think just before our appointment.
Okay. And your appointment was in 2019, so that would be over a period of 4 years.
Yeah, I think.
Yes, and then you also, with regards to beneficiation, you also had a problem?
Yes, we had a problem. That's the 5% that I'm talking about. 5% should have been sold. There were two problems. Firstly, the 5% was based on quantities and not on value. So it also was undervalued and undersold. The second issue was that the 5% was sold to a related company, which was Daniel Nathan, owned by one of the directors. Now, this is a conflict of interest. And at times, they sold it to another company called Geddes, which was also in the same premises where they were situated. And so they didn't see it as a problem, but we saw it as a problem.
Without a license, could they in fact be selling to anyone?
You know, eventually, because they could not provide us with all the information of the bidders, the valuation certificate. They could not tell us how much was sold to which bidder. There was a suspicion because we even confronted the CFO, and we said, you verified the veracity of these documents and you made a payment, commission payment to SSI. Why are you not, why didn't you get the info, why didn't you ask for more information? Supporting documents before you sign off and pay. According to him, no. We sold the SSI are the buyers of the diamonds. I asked him then, did you read the agreement? The agreement is explicit. It says SSI only facilitate the buying. They should not be buying. He said he never read the agreement. And that to me was also another, it's a problem. Because how are you CFO? You verify payments and you don't, and you because you're supposed to check the veracity. Check if these people have been properly appointed. Is an agreement in place? What does the agreement say? So we had all these problems.
Thank you. And what did you find in relation to the relationship? I'm moving to the next
The relationship.
topic. Yes, the relationship between the marine contractors and the JV.
There was a hostile and unfriendly relationship. In fact, the trust relationship had broken down. And according to executive management, they were upset because their concerns were raised in public. They were not approached. However, the contractors met with the executive team a number of times, raised the concerns to them, it was ignored, and as a last resort, they then went public. And there are certain concerns that they raised, which we investigated. For example, they raised the concern that the processing, the diamond gravel processing plant was operating inefficiently. And they were particularly worried about the security controls, of the diamond gravel. Because there are various stages of extraction that's used in the plant. We did a physical walk through the plant. And the first stage is what they call density media separation. Diamonds are supposed to be one of the heaviest minerals. So they use this to separate the heavier material from the lighter material. Now they complained that they were not allowed to use their own traces, density traces. Now the density traces would then test the density. We then approached and asked the operations manager why they were not allowed to use the traces. According to the operations manager, who was Jerome Kluti at that stage, there is no guarantee that the traces have been tested. This was his excuse. And we found this not acceptable because a certificate, you could always ask the contractor to give you a certificate that the trace has been tested. And that is what we told him. And then the second point on the traces was that they were not told the number of traces that gets put into the separate piles. And this was an issue for them because then you don't know what's happening. Now, according to Jerome, no, the contractors are lying. We've got records showing that they acknowledge how many traces are placed in the heaps and how many traces are taken out of the heaps. We then asked for the records showing that the contractors had signed. They could not provide us with the records. Okay? So we found that the complaint and the issue raised on the traces was a valid one. And then there was also the issue of the security control issue in transporting the diamond heaps from the X-ray room to what they call the glove compartment. This is a glass container. And because they use a container that's like, it's a metal milk-like container. It looks like an old metal container. They use that to transport the gravel, diamond gravels, and that's secure. However, because of insufficient numbers of containers, they then use a sack-like bag. And the contractors were very unhappy with it because the sack-like bag was of a poor quality, and you could make a hole in this sack-like bag and actually remove diamond gravel and then close the hole as well. So they were very unhappy. Again, we questioned the operations manager about this. He admitted that they do use the sack-like bag and they don't have sufficient containers. Okay. So this was an issue. And then the other issues that they had was the reclamation of the tailings. Now, the tailings are essentially your residue. You know, it's like your mine dumps that we have in Johannesburg. It's a residue, so it's a dump that they have. Now, the special extraction process that they use to retrieve diamonds from the dumps. Now, they complained that they were not given, they needed to share. In terms of their contract, it's called tailings. They need to share equally the proceeds derived from the tailings. Now, we then questioned the CEO about it. The CEO said, yes, they do qualify to share in the table tailings, but not the stockpile tailings. The agreement does not make a distinction between table tailings and stockpile tailings. The agreement only says tailings. That's all it says. So we found this questionable, and also we did not. It was not part of our brief to investigate the appointment of Alexkor that was doing the extraction of the tailings. So there was also a complaint that they had been appointed to do this, and that Carsten's wife was a business partner of Alexkor.
And Alexkor are the company that were getting the balance of the tailings?
No, Alexkor was appointed to do the extraction of the diamonds in the tailings.
Yes, so the tailings that were supposed to be shared?
Yes, correct.
Okay, thank you. Now I will move you to the last issue that I'm going to deal with, and that's in relation to the governance and management issues. You are on page 131.
Okay.
Now, you found that of the boards, of the committees of the board that were in place, there was a committee that was not authorized to be a committee that's part of them, and that's the tender committee. Tell us what irregularities or what you were unhappy about in relation to the tender committee.
The tender committee was a committee comprising board members. It was a subcommittee of the board. Now, the unanimous resolution stipulated the formation of certain subcommittees. Now, the role of the board, the board has an oversight responsibility. They should not get involved in operational matters. The tender committee, the work of a tender committee, what they did here is similar to what a bid adjudication committee will do. Board does not get involved in operational matters. So we had an issue with that. And there was a good reason why it was not suggested in the unanimous resolution.
Okay. Those are the questions that I have, Chair, for this witness.
What you may have forgotten to do is to give Mr. Torres the opportunity to give his background, his educational, professional background and experience.
Thank you, Chair.
Will you take care of that?
Yes, thank you. Mr. Torres, I only asked you if you were still an executive director at Kobodo, and I didn't deal with that. So can you tell us your experience
Chair,
and your qualifications?
I've got a BCom honors degree in auditing, tax and accounting. I've also done my articles what was then in the 80s known as Piet Mawick, it's now known as KPMG. I am a registered accountant with SAIPA. I am also a certified fraud examiner with the international body and the local body. I have almost 40 years experience in financial management, external auditing, forensic accounting, due diligence investigations. I've done and conducted audits, and well, when I was in the private sector, I did audits on the banks. In the public sector, clients included the Reserve Bank, the Ponzi schemes that we did. We also did the first FICA audit of the 5 big banks. National Treasury was one of our big clients as well. And then we've done across the public spectrum. We've done state entities, provincial departments, municipalities. And then my other experience is working as a financial manager. I've also sat on audit committees, served as audit chair as well. So that's my background.
Okay.
Thank you, Chair.
Okay, thank you very much, Mr. Torres, for coming to give evidence. You may be asked to come back if we feel there is a need, but thank you very much. You are now excused. I don't think anybody wishes to do anything, so yeah, you are excused. In the afternoon, Ms. Bia, who will you be calling?
I will be calling Mr. Gavin Craythorne.
Okay, all right. We'll take the lunch adjournment now and we'll resume at 2 o'clock. We adjourn.
All right.
Ready?
Yes, thank you, Chair.
Okay. let's-
Chair, if I may have leave to call my next witness, who is Mr. Gavin Craythorne.
Your voice has gone down again. You'll have to raise your voice.
My apologies, Chair. I will do so.
Just repeat what you said so everybody knows what's next.
The next witness is Mr. Gavin Craythorne. Thank you.
Well, it's as if I asked you to lower your voice more. Come closer to the mic, I think, because it looks like your voice is naturally soft. Okay.
Chair, my next witness that I will be calling is Mr. Gavin Craythorne. Thank you.
Okay, all right. Please administer the oath of affirmation.
Okay, now stand up.
Please state your full names for the record.
Gavin John Craythorne.
Do you have any objection to taking the prescribed oath?
No?
Do you consider the oath to be binding on your conscience?
Yes?
Do you swear that the evidence will give you the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
I do. So help me God.
Thank you. You may be seated, Mr. Craythorne. Yes, proceed, Ms. Beer.
Thank you, Chair. Mr. Craythorne, firstly, thank you very much for availing yourself, and thank you for approaching the commission when you discovered there were some things that were happening that should not be happening. It takes a brave person to do that, and we thank you for that.
Thank you very much, Chairperson. It's an honor to be here today. I hope I did not disappoint you.
Good. Thank you for coming to give evidence, Mr. Craythorne.
My pleasure.
Mr. Craythorne, before we even qualify you and tell the chairperson who you are and what you do, just tell me very briefly what it was that made you come to the commission.
I'm a
Don't you
founding
want
member.
to- I'm sorry, Ms. Beer, don't you want to get the procedural matters out of the way, get
The
us to
affidavit
admit
admitted.
his affidavit first, then you
Yes.
can go into that.
Thank you, Chair. I will do so. Mr. Craythorne, in front of you, you should have a file that on the spine is written Mining Bundle 04A. Do you have that?
I do.
Okay. Please turn that bundle to just underneath the tab that says AFFI, AFFI. You there?
I'm there.
Okay, thank you. That's page 3,
That's correct?
if you look on the left. Okay. Do you confirm that this is an affidavit that you deposed to? That these are your names at the top, and at the bottom, that is your initial? One of those is your initials.
I do.
And if I take you to page 95 of that same document,
Yes.
is that your signature almost at the bottom?
That is my signature.
And
Well, let's clarify that there are two signatures there. The one above your name, is that your signature?
That is correct, Chairperson?
Yes, okay.
thank you. And the signature that is right at the bottom?
That signature is of Captain Donna van Wijngaard from Alexander Bay.
Do you confirm that when you signed this document, you signed it on the 17th of July 2020 as stated there and in front of the captain?
I do.
And when you were signing this document, Did you swear the oath that this is the evidence, that this is your document and it is the truth?
I did.
Okay. Have you gone through this document recently?
I have.
Do you confirm now that the contents of this document are the truth?
To the best of my knowledge and to the best of my, it's true.
Okay. And do you confirm that in addition to this document, you submitted annexures that you refer to in this document?
Yes.
And that those annexures appear from page 96 of this bundle and carry on to the next bundle, bundle 4B. Do you confirm that those are documents that you submitted to the commission together with your affidavit?
Yes, I confirm that.
Thank you. Chair, if I may, with your leave, ask that the affidavit of Mr. Gavin Craythorne that appears from page 3 to page 95 of bundle 4A and the annexures appearing from page 96 to the end of bundle 4B be accepted as exhibit XX4.
The affidavit of Mr. Gavin John Craythorne, starting at page 3 of mining bundle 04A, together with its annexures, will be admitted as exhibit XX4.
Thank you, Chair.
Okay. You may then proceed.
Yes, Mr. Craythorne, I had asked you to tell us briefly what it was that made you come to the commission.
Chairperson, I'm a founding member of an organization called the Equitable Access Campaign, and I'm also a veteran diamond diver with 35 years of experience in the industry. And the past 20 years, I've been involved in diving diamonds and producing mining vessels for Alexkor. I came to Alexkor in late 1998 when Alexkor first decided to outsource its diver mining operations. And I went through the epic court case as a diamond contractor for Alexkor. I saw that in its entirety. I then went through the period when the deed of settlement was being finalized. It was as if everything had come to a standstill and no real development could take place in Alexander Bay until the court case had been finalized. So we were all looking forward with great expectations once the land claim had been concluded, and people who live in Alexander Bay and in the surrounding areas could get on with rebuilding Alexander Bay into a world-class marine mining center. That did not happen. You've begun to hear today about the decline and the governance dissipation that's occurred over the past few years. And as someone who's lived in Alexander Bay for 20 years and observed the steady and relentless decline in the standards of living, in the condition of the town, in the condition of the mine, and knowing what was driving it, and having already begun trying to raise awareness of these problems even before the Zondo Commission was constituted. When President Cyril Ramaphosa became president, that became the turning point in my difficult journey. And when when your commission was began, I knew that there was a real chance to turn things around, and I must say I feel that today more than ever. And again, I thank you for the opportunity to be here.
Mr. Craythorne, you indicated that you are a member of EAC. What is EAC?
The Equitable Access Campaign is an organization that was founded in 2010 by a group of veteran diamond divers who had enough industry nous to realize that the dramatic decline in our weather patterns was not something that could be ignored, and that the revelations regarding climate change and so on were in fact heralding a very, very difficult period ahead for our industry, because our industry, which is focused on shallow water mining, depends heavily on the correct weather conditions. We work in the surf zone, and the surf zone is a very dynamic zone. And you can't work there when the swell is in excess of about 3 to 4 foot without either injuring yourself or just wasting your time underwater. So you need very, very specific calm weather conditions, which declined from 2000 at the turn of the millennium. We were averaging about between 140 and 160 sea days, to the worst year, I think, was in 2010. I think it was around about 13 sea days. So it's like your business being shut down for 90% of the time compared to the availability that you've had and that you've been used to in the past. And with the pressure that climate change was bringing, it became very clear to the veteran diamond divers that the extremely inequitable structure of our industry would not be able to be supported with the new reality of climate change. Our industry is the only industry that I know of where you have an entire industry that is operated and run by professional people doing the actual mining, but none of whom are actually owners of any mining right. They have access to the ocean to go and do what they love doing, but it is done entirely at the whim of concession holders. And that has always been a weapon that's been used against the small-scale miners to prevent any form of real industry consolidation and unification, and any possibility of collective bargaining. Because every time that we tried to organize ourselves, it would always be sabotaged by underhand tactics and divide and rule tactics. So the EAC actually was prompted by the new legislation, which was based, if you read the preamble to the Mineral and Petroleum Resources Development Act, the entire act is based on the principle and notion of equitable access, which makes perfect sense to me, but it doesn't seem to make sense to the concession owners, who use their consolidated industry ownership to exercise brute force over contractors who, for the past 10 years, I've been basically in a state of servitude because of the conditions and the commercial terms that I'm forced to work under, and all of my fellow diving contractors are in the same situation. So with the arrival of the changes, the fundamental changes of a use it or lose it principle, we felt very confident that, well, this is now going to herald a sea change, if you'll excuse the pun, in our industry. So, you know, a group of veterans, myself and my good friend who's here today, who's been on this difficult journey with me, Mr. George Nicolai, he's been a diamond diver in Port Nolloth 5 years longer than I have. He's been diving diamonds for 40 years. And he's got even more community activity, or he's more of a community activist than I am. But it became clear to us that in order for us to get a better dispensation, a better relationship for our industry, we'd have to rely heavily on the new legislation. And that resulted in us in forming the Equitable Access campaign. We reached out to concession owners like De Beers, Transhex, and the other Northern Cape concession owner, Ms. Ina Visser. We said to them, listen, you guys are not doing anything with your concessions. Why don't you just, give them back to DMR and let the small-scale marine miners do application to get them. That didn't have much of an impact, so we then approached Parliament and we attended the hearings on the mining charter, and we gave evidence to that effect.
Mr. Beer, remember to lead the witness.
Yes, Chair,
Yes.
thank you very much.
Okay, so
He may have a lot to say,
Yes.
but you know the direction that that you want to take him
Yes, Chair.
through. Okay.
So it's difficult to say it all in a few words, Chairman, but
Yes.
I hope that has been sufficient.
No, that's fine. Ms. B, knows
Yes.
what's in your statement fully, and she will, through her questions, she will direct you on the important issues.
I'll focus on the
Okay, all
issue
right.
now.
Okay, all right. Ms. Beer?
Thank you. Mr. Craythorne, so in a nutshell, you are representing Equitable Access Campaign, which is a group of other miners
That is correct.
that you are with that have been doing this work with you.
Correct.
Okay. Can you tell us about your qualifications and your experience? And from there, I need you to also explain how you started your engagements with Alexkor. Briefly.
I matriculated in 1980. I went to the Navy. I did my diver training in the Navy to what they refer to as a clearance diver 2. After leaving the Navy, I worked under the late Dr. John Gurney, who had a small operation in Durham Bay.
Mr. Craythorne, how long have you been diving?
I've been diving diamonds since 1985. So I've got 35 odd years of diamond diving experience, 20 of which have been as a contractor for Alexkor.
Okay, thank you. What else do you do other than actually dive? What else do you do that's related to diving?
I've always been fascinated by the possibilities that mechanizing diver mining might have for the inshore as opposed to the offshore mining. So I've been designing and building diamond mining systems, starting off with very, very small, cheap and nasty ski boats to much more advanced 50-foot vessels today. I've built 40% of the diamond mining vessels that have ever worked in the industry have been built by me.
And how were you introduced to Alexkor?
I was approached by the then production manager of the marine operations, Mr. Tina Swart, to build a 26-foot buttcat mining vessel for Alexkor, which I did. I believe it was in 1993. And as it was flowing out of that, I became interested in the affairs of Alexkor and the possibilities, because Alexkor does sit with the most exciting diamond licenses that I know of anywhere in the world.
Do you still design and manufacture mining vessels?
The last vessel that I built was for the late Dr. John Gurney and his son, James Gurney. They had approached me in 2013 already to buy a share in my business to build a vessel to bring into operation Alexkor's operations, but we never made headway. So I built it for them and they took it to Transex at the Punt, and that was the last vessel. That was 2013, I believe. That the last time I built a mining vessel.
Okay, Mr. Craythorne, if I can take you to page 119 of the same bundle. You'll see that we are already in the middle of a document when we get to page 119. So if we can first go, or keep your place in page 119, and then just turn back to page 106. You confirm this is your CV?
That is correct.
Okay, and that the page on page 119 is part of your CV?
That is correct.
Okay. Now, if you look at that page 119, and you look at the second vessel that's being mentioned there, I see the name Alexkor Limited. What does that mean?
This is a schedule of all of the turnkey mining vessels that I've built over the years, and that is the DMV, which is the acronym for Diamond Mining Vessel, Sea Delver 7, which was a 25-foot buttcat mining conversion that I built under contract to Alexkor, and I see it was 1993.
Do you still produce, how long after this did you continue producing vessels for Alexkor?
Well, it was at this time that Alexkor started becoming more focused on political matters. And it had been the intention to develop a fleet of these vessels because they're very cost effective in comparison to the vessels that Alexkor had been building for itself over many years. Large steel vessels are not very cost effective for working in very shallow water, whereas small agile catamarans are much more effective, much more cost effective.
Okay. Am I correct if I take you 2 pages before page 119? Turn again to page 116.
Yes.
Am I correct that from page 116 up to page 130?
Yes.
Those are vessels that you built or had a hand in?
That is correct, and you'll notice that many of them are barges which have been exported to riverine mining jurisdictions like Angola, Congo, Sierra Leone, and so on.
Okay, thank you very much. Now, when did your relationship with Alexkor change from being a service provider providing vessels to being a mining contractor?
Alexkor outsourced its operations for the first time in its history in late 1998, and when the notices went out for independent contractors to apply for contractors, I did, and I was successful, and I began contract mining, operating a small 35-foot ski boat out of Alexander Bay Harbour in the last quarter of 1998.
Okay, and has that relationship endured until now?
I've been a active producer of diamonds for Alexkor, except for a period
Page 4.
Between 7 November 2017 to 19th of March 2019. Those 16 months, I believe it was, were months during which my contract had been effectively cancelled and my access to the mine had been blocked.
Okay, thank you. But you are back now working with Alexkor, the
From,
PSJV or Alexkor?
yeah, well, it is a PSJV. I was an Alexkor contractor up until the inauguration of the PSJV in 2012, and I, to this day, with the exception of those, with that interregnum, I've been a contractor to the PSJV.
Okay, and the other members of the EAC, are they also contractors to the PSJV?
That is correct. The EAC members are all have either are or have been formerly contractors to Alexkor. There are one or two members that have contracted on non-Alexkor concessions, but they are probably only one or two.
Now, who determines where you can mine?
That depends on who owns the licenses. The West Coast diamond area is divided up into a grid alphanumerically running numerically north to south and alphabetically east to west. Those concession blocks are approximately 40 kilometers long. In the shallow waters, they run a kilometer out from the beach, and then you have the B concessions, which run about 5 kilometers. But where you work, first of all, depends on who you have a contract providing access to go and mine.
So in this case where the EAC is contracted to the PSJV, is that what you are saying?
All of the members of the PSJV all have contracts with the Alexkor PSJV to mine on the concession areas that they control and have ownership of. Now, having first gained access through a commercial agreement with a concession owner, the second level of access is governed by a cadastral system using very basic GIS technology where you use map data, digital map data, and then you use area marking system that you can register where you would like to work, and you may go and register areas and work them as long as they haven't been registered previously. And the standard area that we are allowed to mark as a 30-meter radius. So for instance, on Alexkor's 1A concession, running from the Orange River mouth about 40 kilometers south, you have maybe about 40 contractors that have contracts with Alexkor, and then they have 3 areas that they are allowed to mark along the coastline. And you're also allowed to move those areas, but you have to do it through a formal registration process done through the registry on the mine. And the registry on the mine keeps track of where all the various contractors are working and to ensure that they are working in their registered blocks and to allow for cancellation and re-registration of these blocks.
Okay. Now tell me, when you mine in these areas, what is the time frame that you are allowed to mine, and when is it determined that you need to now bring your hauls? Is there a time period that applies to when you can mine, when you can't? What determines?
you have what we call a weather window of opportunity. So, as I've explained, diver-based mining is highly dependent on calm weather conditions, and more specifically calm sea conditions, because you can have atmospheric conditions that are quite bad, but the sea conditions can still be quite good. So then it's more comfortable underwater actually than being on the vessel, because the vessel's been blown around and maybe dragging anchors and so on. But it's weather dependent, and also on capacity of the vessel that you're working. The amount of gravel that you have to produce, generally to produce 1 carat of diamonds, my grades used to be in the order of 12 carats on a cube. That's a cubic meter of gravel. But the vessel that I operate can hold about 30 cubes, and the density of marine gravel is about 1.6 tons per cube. So you're looking at around about 50 tons of gravel to produce a mere few grams of diamond. So when the vessel is full, you have to come and offload, or if the weather conditions are prohibitive, then even before the vessel is fully loaded, you have to return to the harbour and offload what gravel you do have and sit on the moorings until the weather improves.
Yes. Now, if you can tell us about Scarlet Sky Investments and your relationship with them, and bearing in mind that we've already heard the evidence of Mr. Torres. So when did you start having a relationship with Scarlet Sky? Do you have a relationship still?
The only relationship that I have with Scarlet Sky is a pending Kimberley High Court slap suit, which has still yet to be resolved, which they brought against me for defamation. But other than that, I've had no relationship with Scarlet Sky. They have simply been brought into my life as a contractor through the decisions and behaviors that were highlighted earlier today. So the adversarial nature of my relationship with Scarlet Sky began in 2016, because the minute that Scarlet Sky was awarded the contract, there was a lot of consternation amongst my fellow contractors at the time about the lack of transparency and the secrecy about who Scarlet Sky was. It was a strange name that nobody had heard before. No mention of diamonds anywhere in it. There was no track record. I myself at that time had, while still being a very active member of the Equitable Access campaign, I had not been able to focus too much attention in the early years from 2015 on Scarlet Sky, because I've been very involved in developing a piece of technology that's capable of being able to penetrate through the sediment overburden. Besides the politics and the dissipation in governance, the other factor that's prevented Alexkor and South Africa developing its marine mining. Ms. Abia, how did I get the relationship?
Yes.
Beg your pardon, sorry.
So you heard the question.
Yeah.
Yes, you can intervene when the witness seems to take long to answer your question.
Okay, so in the initial stages, I was not involved too much with the kickback from the contractors over Scarlet Sky, because I was devoting my attention, and I'd been traveling overseas.
It's okay. Thank you. Okay, so you weren't. Thank you.
Yeah.
Now tell me, in the chain of how the diamonds go from the mine to the public, tell us about that process, because you've told us where you can mine, you've told us what, you said the size, the size
The
of
volumes of gravel.
Yes, yes, and all of
Okay.
those things. So tell us about that process. From, you now have this, you have a contract to mine for the PSJV. What happens from when you mine to where I buy my ring?
Okay. So as marine diamond mining contractors, our job is to produce diamond-bearing gravel off the seabed. We do that using specialized equipment designed specifically for that. We deliver the ore that we mine off the seabed to the harbor in Alexander Bay. That bulk gravel is held for a period at the harbor, possibly a day or two before it is transported inland to Alexkor's plant, situated near the administration building.
Is this done by the contractor? The mining contractor transports it to the
No,
Alexkor mine?
the contractor delivers the gravel to the harbor, and as soon as that gravel is offloaded from the vessel, control over that gravel falls into the hands of Alexkor, or the PSJV in this case. So Alexkor PSJV then transport the bulk gravel to the plant. When it arrives at the plant, it will be put into a gravel pound, which is fenced off, where there's security access. And it is usually the case that you don't bring your gravel straight from the harbor and put it into the plant, because there are other contractors that are ahead of you that are processing gravel. So when you arrive at the plant, you will stand in a queue. You might have to wait an hour or two, but when your gravel is ready to be processed, they will flush the system, and then they will start what we call drawing your gravel out of a surge bin.
Is that done in the presence of the contractor?
That is correct. The contractors are called to the gravel pound when it is time to fill the bins, and it is the contractors working together with Alexkor PSJV personnel that use a front-end loader to hoist the gravel up above the feed bins, and then the contractors manually open up the bottom of the bulk bags to allow the gravel that's been placed in it while out at sea. Because when we mine out at sea, the gravel that gets kept on the vessel to be processed is only a certain fraction of the full amount of material that comes off the seabed. So it's maybe plus 2 millimeters, minus 25 millimeters that gets retained and stored in those bulk bags. But at the plant, those same bulk bags that get filled while you're out at sea then get emptied into the gravel bin. From the gravel bin, the gravel then reports to the first phase of the recovery process. And that is to reduce the bulk of the diamond-bearing material.
Okay, Mr. Craythorne, I think you are possibly giving us too much detail.
Okay.
So what I need you to tell me are the steps that
Before it gets to the
that are
sales.
involved, yes,
Okay.
in the process.
So,
And when you are explaining that part, all of that, you must just remember to tell me whether the contractor is there, the contractor is keeping an eye on what's going on, or who is doing what. But
Okay.
very high level, Mr. Craythorne. We
Understood.
don't want to
Yeah.
know about the separating and what falls out and
Understood.
at the stage.
So when it arrives at the plant, it goes through three distinct phases, where eventually, from perhaps 50 tons of gravel, you'll end up with maybe 10 or 15 carats. Sometimes you have a huge amount of diamonds from very little gravel, and the converse is also true. The grades are very erratic. But the time that the gravel is being processed inside the plant is controlled by PSJV personnel called plant operators. In addition to the plant operators, there are also outsourced security personnel and in-source security personnel that patrol the plant. And as the gravel progresses through the plant, the risk of theft grows greater, because you start off with a very large needle in a haystack. You start off with a needle in a very large haystack, and that haystack gets progressively smaller and smaller. And as the haystack gets smaller, the risk of theft becomes greater, because it's easier to...
Is the contractor there at the time?
The contractor is not there all the time, but the contractor is always at the final recovery, where the diamonds are fed onto, the super concentrate, the remains...
Oh, Mr. Craythorne, don't tell us about the super concentrate. Okay. In that much detail.
That's where the glove boxes are.
Yes, but you need to tell us that the diamonds get from the harbor to this place for the purposes of sifting, for example. I don't want to be feeding you evidence.
Okay, so
but I'm explaining that we don't need to know the actual process as if we are present when this is happening.
So when it comes to matters that you know are not controversial, you can later on those.
Yes.
On matters which you know won't be disputed by anybody.
Thank you.
Like I'm sure the processes that you're talking about.
Yes.
Yeah.
Yes.
Okay, thank you, Chairperson. So once the product has been recovered, it then gets weighed in through a process controlled by Alexkor. There's a register, a little register, which is colloquially referred to as a inweegboekie. The inweegboekie is a book which is countersigned by the contractor as well as the Alexkor PSJV representative, where you record the quantity and the weight of the diamonds that have been recovered, and generally stones over 1 carat are weighed and recorded also individually.
And then what happens when you have recorded the stones that have been recovered?
At that point, the diamonds are then put into a safe custody, and we are given a receipt out of the inweegboekie. And unless you go to the sales, that is the last that you see of your diamonds.
What happens to the diamonds?
So the diamonds then are... they accumulate during what is referred to as a production cycle. So a production cycle is the period from when there's a production cutoff to enable the mine to reconcile its production for a period and prepare the production in that period for sale, and when the next period starts. So
So the diamonds are kept in whose custody?
It's
in
kept,
the PSJV's custody during this period?
During this period, while the diamonds are still on the mine, it is kept in the PSJV safe custody.
And when the production cycle is finished?
At the end of the production cycle, they issue a close-off notice to say to the contractors, no more production will be included in the upcoming sale beyond a certain date. So if they issue a cut-off date, say for the end of January, say what usually happens is you have a flurry of processing taking place before the plant closes, but at the end of the day on January the 30th, no more production will then be included for the upcoming sale.
So what happens to the diamonds at the end of the cycle, the diamonds that have been kept in the custody of the PSJV?
Those diamonds are then counted and weighed and sieved, what they call, well, you have two.
No. That's too much detail.
Okay. Well, at the close of the production cycle, the diamonds are then transported up to Johannesburg for presentation to the state diamond trader.
By whom? Who transports the diamonds up to Johannesburg and who presents them to the state diamond trader?
I do not know who transports the diamonds from what we call the mine gate. It's an industry term. When your diamonds leave the mine, you talk about the diamonds leave the mine gate. We don't know who conducts that service or what form of transport is used, but the diamonds are transported to Johannesburg, and then they are placed into a safe and secure area called Knox Vault in Johannesburg, where Daniel Nathan has his premises. It's below the place where Kuben Mudli has his safety deposit box.
Okay, we don't know about all of that.
Okay.
Whose custody is it given to?
It's given to Scarlet Sky.
So it's only given to Scarlet Sky when it arrives in Johannesburg?
That's my understanding.
Okay. And then, that is the level of the relationship that you have with Scarlet Sky. What do they do with the diamonds that you have mined?
The diamonds that the contractors, such as myself, mine, are first.
Remember, we're now just talking about Scarlet Sky. And what do they do when they receive your diamonds?
When they receive the diamonds, they prepare them for viewing for the state diamond trader to select their 10% representative sample. They select 5% for beneficiation, and the balance, 85%, then goes on auction at their premises. But I've never been to those auctions. Some of my colleagues have been up to the auctions, but I've never been. And
then you next hear when you get your money. Is that when you next hear what has happened with your diamond?
Well, a sales cycle from the time that the diamonds leave the mine gate until the time that they've gone through prep for the auction and the payout is usually about 2 weeks. It's about a 2-week period from the time that your diamonds leave the mine till the time that you get paid out.
Okay. So, you have said that your relationship, you did not have any problem with SSI at the beginning.
I did not have any problem with SSI in the beginning.
Okay. And who determined the price at which your diamonds were being sold?
Well, the diamonds are supposed to be valued on the mine for 2 reasons. Number one is to insure the diamonds for their fair value. Because if you do not analyze your diamond production, you cannot attach a fair value to the diamond. So you can't just look at the size of the diamonds and the stone size frequency distribution. You've got to analyze the color as well. You've got to look at the special stones.
Yes, so who determines the value at which your diamonds are sold?
It's a lady by the name of Michelle Adams, who is an employee of Alexkor, who is involved in the management of the final stages of the diamond recovery process. And
so
then
the value of the price at which your diamond will be sold is determined by Ms. Adams?
No, she doesn't determine the price at which it's sold.
That's the question.
No, she doesn't determine the price at which it should be, at which it would be sold, but she makes a very inaccurate assessment of what the value is in order for insurance purposes.
Yes.
Did you
Now-
say inaccurate?
Yes, because any valuation, Chairperson, based solely on the size, which is the first of the 4 C's, the carat weight. So if you pick up a rough diamond and it weighs 4 carats, you can pick up another diamond that also weighs 4 carats, and simply because of the difference in the other 3 C's, one stone could be worth $40, and the other stone could be worth $40,000. So by simply conducting a valuation on the basis of stone size is a wasted exercise.
So you say that she conducts effectively a useless exercise?
That is correct.
Yes. Ms. Beer?
Thank you. So
I think your question still stands.
yes, it does.
Ultimately, when you sell the prize, that's what she
Yes.
wants. Who determines how much you will sell it for?
That is supposed to be determined by what we call price discovery.
Price?
Price discovery.
What is that?
Proper price discovery is where you have a competitive bidding process where buyers.
An auction.
An auction is a classic example of true price discovery, but the auction has to be an honest auction. If you have collusion, then you're not going to have price discovery. So if it is an auction that is designed to allow for sharing of critical price information, then you defeat the whole price discovery mechanism.
But there must be a basis upon which somebody who has the relevant knowledge and expertise and experience should be able to say, if you take this piece of diamond, that person having analyzed, conducted whatever analysis is required, should be able to say, if you go to sell it at an auction, you should fetch not less than so much and maybe not more than so much. So therefore, its price must be in the region of. Somebody must be able to say that, isn't it?
In a fair world, that would be the case, but for as long as I've been a contractor at Alexkor, contractors have never been allowed to critically analyze the value of their diamonds. You have a brief look when you recover your diamonds, but then it goes to the auction process. In the case of Scarlet Sky, and previously it was an auction process conducted on SIDEX, which is South African Diamond Index, which Alexkor had been using. And in earlier years, it was done on an exclusive purchase agreement where there was absolutely no price discovery. A subsidiary of De Beers would come and look at the diamonds, set a price, and take the diamonds. So the history, in the time that I've been a contractor for Alexkor, the history of diamond pricing has been an extremely contentious issue, with the exception of the period between 2006 until 2011, where there was a reasonable period of price discovery. You will always have collusion at auctions, but you need to try and control it and put countermeasures in place to make it as difficult as possible. When in 2006,
I was going to say, you seem to be wanting to drive us.
okay, but it's not as simple to say, how does the diamond price?
Ms. Bia, continue.
Yes, I don't think you've actually told us
Well,
who determines.
the buyers determine it.
Okay, so it's the buyer that determines. Does anyone set a benchmark that it must not be lower than this price?
Well, that is where there is a big problem in the case of Scarlet Sky, because the company that is conducting the auction is also the company that is doing the valuations. So if there is collusion taking place during auctions and the prices achieved on auction are extremely low, there is no safety measure in place to prevent the sale of the diamonds. So your reserve price is extremely important, because if you have collusion and you have an honest reserve price, you won't have sales going through.
So the reserve price is set by SSI.
The reserve price has been set by SSI since late 2005 for the period from about March to October.
2005?
Sorry, 2015, I beg your pardon. There was another valuator that was valuing the diamonds. That valuator was dismissed by Mr. Carstens. And then the function of valuing our diamonds was then given to Scarlet Sky.
So how do you, as a miner, know that your diamond is being undervalued or is being sold at the right price?
You don't know on a sale-by-sale basis. Now,
this question is being asked because you have alleged in your affidavit that,
yeah, but I'm qualifying
that they are being sold
Yeah.
for less than their value. So
on a sale-by-sale basis, it's very difficult to pinpoint, because the type of production that you have can vary on a sale-by-sale basis.
Mr. Craythorne,
Okay.
you are telling
So-
me how it is difficult
Okay.
to ascertain. I need you to tell me, you're saying that on a sale-by-sale basis,
Yes.
you can't say that your diamond is being sold for a lower value. So on what basis can you tell?
Statistically, using statistical methods, using longitudinal studies, which is what I've done, is I've tracked Alexkor's pricing from 2000, using very basic statistical treatments. I've used the price data that Alexkor provide with every sale. I've then created indexes for the various assortments of the mixed goods, which are the diamonds below 6.8 carats. Diamonds larger than 6.8 carats are not sold as mixed, what we refer to as mixed goods. They are sold as individual diamonds, and the pricing information relating to those individual diamonds is only disclosed to the person that actually mined the diamond. Whereas in the case of the goods below 6.8 carats, there are 14 standard assortments into which all of the diamonds below 6.8 carats are sorted into using a standard sieving process. So you'll have your 5-carat diamonds, your 6-carat diamonds, your 4-carat, and so on. So
you said you created your own indices.
I created my own indices based on the information that's published for diamonds below 6.8 carats. I then benchmarked that pricing data going all the way back to 2000, because the Zimnisky index data goes back to 2000, and I began really working at Alexkor around about that time. Diamond Dell only arrived in 2000, and it was at that point that we started receiving brokers' notes with a breakdown of what the prices are, because the diamonds that you produce, you are paid out pro rata on your contribution for each category.
So what do you put, you've now mentioned the Zeminski index. What else do you use to compare and see?
So what I've done is I've tabulated all of the pricing data over 20 years. For each of the standard 14 assortments, I've created indices for each of those assortments, which I've then benchmarked with the Zeminski index. And what's important when you're analyzing diamond prices is not the absolute price, but the relative price. Because you don't, by looking at the absolute price, you don't know if you got a good price or not. You need to look at what the market is doing at that particular time and compare what your price was for similar goods at the same time. So, starting in 2000, I compared the pricing behavior of each of the 14 standard assortments of Alexkor diamonds against an internationally recognized index, which demonstrated very, very clearly that from 2000 to 2006, there was a rapidly increasing tracking error. Now, tracking error is simply the difference by which the asset that you are interested in is differing in relation to the market in which it's been sold.
So how much
Ms.
it doesn't...
Leah, just remember to keep your eye on the relevance and importance of
Yes.
some of these things
Yes,
in relation to what we are looking at.
we are digging, Chair, but that's where we're going.
Yeah, just keep an eye on
So
the
to-
real issues.
Yes.
To sum up then, Chairperson, the prices of Alexkor's diamonds deteriorated dramatically in relation to the international benchmarks between the period 2000 to 2006. When Alexkor went onto the open market from 2006 to 2011, the prices performed much, much better, significantly so. And from 2011...
Did they then correlate with the market in general?
Yeah, so when there was very little correlation in the first period from 2000 to 2006. There was a period of normalization from 2006 to 2011, and where prices were very closely correlated with what the market was doing. And then subsequent to 2011, from 2012, they again worsened dramatically.
What changed in 2012?
In 2012, all of South Africa's rough diamond prices suffered a massive drop. The drop came about as a result of a piece of legislation that became effective in 2011. It's Section 20A of the Diamond Act. Up until the end of 2011, when rough diamonds were sold locally in South Africa, licensed diamond buyers were allowed to visit auctions in Kimberley or in Johannesburg, anywhere around the country, in partnership with international buyers. What Section 20A did was it prohibited local licensed buyers from being accompanied by international buyers. So that took out the international competitiveness out of South Africa's local auction system. It caused such a lot of consternation in the market. It resulted in a constitutional court case, which was finalized, I think, in I don't want to quote the date, but it did find its way all the way up to the Constitutional Court. And it was based on the issues around Section 20A.
Yes. Now, you say in your affidavit on page 5 that by 2013, in paragraph 14, you say by 2013, the marine diamond production of the PSJV traded on average at 30.2% below the market.
That's correct. That is a weighted average. So it's, to make the analysis more manageable, and for purposes of this submission, I took the 14 indexes that I created and fused them into one general index, but taking into account the different weightings, because different categories of diamonds have different values, and depending on the quantity that they make up of a production affects the overall average price. And based on that composite index, by my calculation at that time, Alexkor's prices were trading 30.2% below the market.
And what was the response of the EAC to this, to the fact that their diamonds that they were mining were trading 30%, 30.2%? Was there a response by the EAC?
No, at this stage, the EAC was not very active in dealing with this matter.
So what was the response of the joint venture? What did they do to counter what they saw as the falling prices?
Well, the PSJV, like everybody else, was very alarmed. And their analysis of the situation was that there was a problem with the current service provider doing the marketing and sales, called Diamond Marketing Consultants. And the technical committee of the PSJV made a recommendation to the board that the board rotate the then marketing and sales service provider to do a test.
How do you know this, those intimate details of what was happening inside the JV?
Well, that the contractors were informed by the PSJV that the PSJV was very unhappy with the price performance under the then service provider and wanted to do a trial run using a new service provider. So they brought in a company on a trial basis called Fusion Alternatives, and for a period Fusion Alternatives then took over the function from the previous service provider.
And did the prices improve?
Not markedly. In fact, in some instances, they actually deteriorated further.
And it was at that point that the PSJV advertised a tender that resulted in the award to SSI, am I correct?
That is correct, and in hindsight now, that should be the point at which the PSJV should have realized that we were dealing with a problem totally unrelated to the marketing and sales. The etiology of the problem lay somewhere else.
Okay.
But they pushed on ahead and got permission to launch a tender process to bring in a permanent new marketing and sales service provider, which culminated in the issuing of a tender in 2014 in October, I believe.
Okay. Now, Mr. Craythorne, you go into a bit of detail in your affidavit regarding what you call irregular tender process followed in the appointment of Scarlet Sky. You've heard the evidence of Mr. Torres before you. Now, firstly, just explain to the chairperson how you came to have the detail that you've included in your affidavit, because we understand that Mr. Torres, his company was instructed by the department to conduct an investigation. So where do you get the authority to speak to these things? How do you know these things that you are speaking about here?
Chairperson, from 2016 through from 2015, when Scarlet Sky started marketing and selling our diamonds, through 2016, the diamond prices got progressively worse. It was generating a huge amount of anger amongst the members of the EAC. My fellow EAC founding member, Mr. George Nicolai, would regularly be stopped in the main street of Port Nolloth by angry members asking us when are we going to do something about the problem relating to diamond prices. And in 2017, I then did a very brief analysis which reflected the difference between the international prices and what we were getting. And I then posted those prices at the entrance to the mine. That was at approximately 4 o'clock in the morning when I was actually on my way to go to sea. I didn't think it was a big deal. Everybody knew that there was a problem. So I thought, well, I was doing everybody a favor by just adding some, analytical contribution to the consternation. That had some very immediate and severe consequences. The data that I put up was in the form of a curve, a index, basically just comparing the performance of Alexkor's diamond prices with the market. And there were security cameras filming this taking place. The security, unbeknown to me, because I put the data up, went into the mine, and went to sea. And when I came back a day or two later, there was a very angry letter from Mr. Mervyn Carstens saying that I was causing trouble by trying to generate anger amongst the contractors and our members for posting untrue information at the entrance to the mine. And I was warned that I would be suspended if I continued to cause anger amongst the members, when in actual fact it was the anger of the members that was driving me, not the other way around.
And then what was the outcome of that? Because remember, you are answering the question of how did you come to know about the irregular tender process?
I was warned to back off on the issue of the diamond prices, which I did for a while, but because the problem just was getting so out of hand, I started making further inquiries about who were the individuals behind Scarlet Sky, because nobody knew. So I wrote to Reagan Phillips and I requested information. That information was denied, and the situation escalated to the point where my contract, first of all, my access into the mine was cancelled. Shortly thereafter, the contract upon which Ocean Diggers operates was also cancelled, together with my fellow EAC colleagues. And following that, I then put a lot of effort into trying to get to the bottom of what was going on.
Because you had all the time.
Because I had the time now. So I started digging, and I started collaborating with other people in the anti-state capture project, you could call it. And it was brought to my attention that one of the shareholders in Scarlet Sky was Mr. Kuben Moodley. And that was the point at which we realized what was going on. And
what did you know about Kuben Moodley?
Well, he had been mentioned in the Public Protector's State of Capture report, and that was good enough for us to say, well, look, there's a problem here. So his name popped up, in Amabungani and Daily Maverick and all over the show.
In what context did his name pop up?
In relation to there was irregularities at the SABC. There was irregularities in relation to Transnet and Eskom.
And
so-
how did he feature there?
He featured as a close lieutenant of the Gupta family.
Okay.
So with that knowledge in hand, I then again confronted Mervyn Carstens and said to him, listen, you need to do something about this because this is why the diamond prices are so shocking. And I wrote a very, very confrontational email, but I felt it was the only thing that I could do at the time, where I said straight out, listen, you're dealing with a state capture issue here. Yeah, and you need to suspend this contract immediately. You need-
Okay, remember you are answering the question.
Okay, how did I get the information?
Yes.
Well, far from being received, with my efforts to help understand what was busy going on, were met then with some threat from Weber Wenzel on behalf of Mr. Carstens, where they threatened me with legal action if I did not refrain from, sorry, I beg your pardon, yeah, it was Weber Wenzel. I've had 2 slap suits. And I refused to back down, so I got hit with a slap suit, and I found myself very quickly having to learn how to defend myself, and that's when I started looking even closer and closer and digging into what was going on. I caused certain questions to be asked in Parliament via Veronica van Dijk about who these guys were, what licenses did they have, and I had to very, very quickly get to grips with the law because my life depended on it. So I successfully defended myself against Weber Wenzel and Mervyn Carstens, only to 1 month later being hit with another slap suit from Mr. Vikbler and Kwashu.
Mr. Craythorne,
That's where I got that information. That's how I learned. I had to defend myself, Chairperson, and
so
Did
where
you get
did you
some of the information from the court papers that were served on you?
no, my court papers.
Or when you were
Yeah,
prepared to defend yourself?
When I defended myself on the basis of you guys are acting illegally because you don't have the licenses, and I confronted them
But how did you know that they did not have the license?
because they were told them, because the questions that are caused to be answered in Parliament admitted that they did not have the license.
Okay, can I refer you to page 270, 270?
Okay, and there.
Is this the question you are talking about? Because you mentioned now that you mentioned a Miss Van Dijk.
That's correct, yeah. So this is the
At
question.
Page 200 and
270.
217,
No, 270.
270.
Yes, yes, Chair.
This is the parliamentary question which I caused Ms. Veronica van Dijk to ask in Parliament.
Question number 1267.
That's correct.
Did you ask all these questions, or was there a specific one that you were asking?
I provided the questions to Ms. van Dijk, and she processed these questions through Parliament, through their processes. And then the answer was provided, and it's recorded here on page 272.
Okay, so the first question that you caused to be asked was the question marked 1.
That's correct.
And you were questioning if there was a track record for Scarlet Sky Investments prior to them being appointed by Alexkor.
Correct.
What made you ask this question?
because it was one of the minimum requirements, or rather it was part of the tender specifications that had been issued when the PSJV sent out their RFP.
So you remember this in 2018, that there had been this issue in 2014?
Well, I looked back in the records to find what, at the time that the tender was issued, what the specifications were.
What put you in a position to question these things? What information were you armed with that led you to dig deeper and ask these kinds of questions? You've told us about your court case. Was this after your research? What did you discover in your research that led you here?
Throughout the period from the time that my access into the mine was cancelled, I began a rigorous process of discovery, trying to find out. And that was an ongoing process right up until the time that I finished my affidavit for the Zondo Commission.
Okay.
So it's been a process of discovery, and the revelations that have come about have been through a process of ongoing research and requesting information, contacting the regulator to inquire whether Scarlet Sky in fact did have a license. And they informed me that Scarlet Sky did not have a license. So I wasn't only just relying on one source of information, I was double checking it through the regulator as well. So both the regulator and Department of Public Enterprises confirmed that Scarlet Sky did not have the minimum requirement of licenses.
Okay, so let's go back to page 270.
Okay.
So the question that was asked was whether Scarlet Sky Investments had a track record prior to its appointment, and the answer appears below at the bottom of the page. And the answer that they gave was that Alexkor gave was that the company had no track record until Mr. Daniel Nathan, with 20 years experience within the diamond industry, was appointed as a director of SSI in 2014.
That's correct.
Okay.
Even that must be inaccurate, because that's not the track record of the company. That's the track record of an individual.
That is correct. And the date, his directorship only became effective on the 4th of December. So he was appointed in November.
Yeah.
But the records that I accessed show that he actually only became effective as a director on the 4th of December, even after the tender process.
But the fact of the matter is, if you answer the question whether the company had a track record in this industry, the answer is no.
Correct.
The fact that at some stage an individual got involved in the company who had 20 years experience doesn't give the company 20 years experience track record.
That's how I looked at it.
And the next question was question 2A, why has no beneficiation for the community taken place since the appointment of the specified company by Alexkor? And what are the details of how transferring the sale of diamonds to the company has impacted on the value returned to Alexkor and the miners? Why did you ask this question?
I asked this question because that was one of their main selling points.
Whose main selling point?
Scarlet Sky. Because when we were, as contractors, raising major concerns about their poor performance in attaining fair diamond prices for us, there was feedback from the PSJV saying that they were doing a lot for the Richtersveld community.
And the answer that they gave was that beneficiation is taking place in Houghton and has been taking place since 2015, and that SSI currently employs learners from the community.
That's correct, but as far as I'm aware, there have been no lasting, or there, as far as I know, there have been no qualified cutters or polishers that have emerged out of any of the commitments that Scarlet Sky made to the Richtersveld community.
They continue to say beneficiation contributes an additional 9% income to the pooling and sharing joint venture to income after the tender process.
Well, part of the agreement with regards to beneficiation of diamonds was that the contractors would share in any upside. And to my knowledge, no contractors have shared in any upside of the diamonds that have been taken out of the production for beneficiation. So if there has been 9%, that should have been shared in the same ratio as the contractor's contract to mine those diamonds stands. So if a contractor has a 50% deal to mine a diamond for Alexkor, and that diamond then goes for beneficiation, you get paid out on a valuation price, but whatever the upside is, subsequent to polishing and the sale, if there is a 9% additional value add, that was supposed to have been shared 50% to the PSJV and 50% to the contractor after the beneficiator had taken his percentage.
The next question is, on what basis was the company, SSI, again awarded the contract in November 2016? That's the first part of the question, and then they continue with the next part of the question. Now, their response to the question posed on 3A, on what basis was the company again awarded a contract in November 2016? Their response is long, but at the end of it is that it says, well, let me start at the top. It says the process included the RFP, which was advertised in the government tender bulletin of 31 October 2014, as well as the business day of 2014. Do you agree that this was not for the 2016 tender?
No, that's for, I beg your pardon, that was for the previous tender.
Yes, and then it continues. 7 companies expressed their interest in RFP 03 of 2014 and submitted proposals. Also in relation to the previous one.
Yeah, because the convention, the numbering convention that you see in the RFP relates to the year, the 2014, indicates that that was an RFP from 2014.
Yes. And then it continues and it says, Gamiro Advisory Services were appointed by the Alexkor PSJV board to evaluate the proposals received.
That's correct?
The top 3 companies, according to the evaluation scores, were invited to present to the Alexkor PSJV board tender committee.
Correct.
Following the presentation and assessment of the SSI bid proposal, the Alexkor PSJV board was satisfied with the prices and proposals submitted by SSI. The Alexkor PSJV board appointed SSI with effect from 1 March 2018. Is any of this correct in answer to the question of on what basis was the company awarded a contract in November 2016?
Not at all.
Why do you say that?
Well, it doesn't make sense because they're conflating the first tender process with the second tender process, and they talk about a date being an effective date being the 1st of March 2018, which it couldn't possibly have been.
Because the question is specific, yes,
Yeah.
is specific to 2018, to 2016, sorry. So Alexkor didn't answer this question.
No.
The next part of the question is, why is there no longer an independent valuator model included in the company's contract? You can see their answer there in B.
Well,
And it says the independent valuator process was stopped after some of the contractors complained about beneficiation, and it was decided that the diamonds selected for beneficiation process will be paid based on the tender price of the goods.
Well, I don't know what to make of that, because again, it seems to be conflating different issues. For instance, the original bid that Scarlet Sky made, and the basis upon which they were provisionally awarded, successfully awarded the tender at the close of 2014, was an exclusive purchasing agreement akin to what was in place from 2000 to 2006 with Daimdel. And they had made it very clear, according to their expert opinion in their bid documents, that because of the introduction of Section 20A, auction processes would no longer be the optimum solution for achieving fair diamond prices, and that Alexkor would need to consider what they refer to as a proprietary independent valuator model. So they were trying to resurrect the same arrangement that we had fought so hard against when De Beers were buying Alexkor's diamonds. And that bid, which had cast aspersions on the tender system, or their tender documents, all of a sudden in January, without any explanation, they do a flip-flop and change their proposal from what they had initially proposed, which was what they refer to as their proprietary valuation model, to the tender process. So something happened over the holiday period, resulting in a complete about-turn by which they then embraced the same sales model which they had themselves cast aspersions on. And then on top of it, won the tender.
And the next part of their question is, who made the decision? Now, I'm not sure whether the decision that is being referred to is the absence of an independent valuator model, or whether the decision they're talking about is the award to SSI.
It seems to me they've cannibalized some facts and mixed them up, because in a certain way it is true, they did abandon the valuator model, but they abandoned it over December, and yet for the first year there was still an independent valuator. So it seems to me that even though this company had agreed that tender was the way to go, that at least for the first few sales that were conducted, they were done on a valuation basis, not on an auction basis. And at the point at which the independent valuator then became redundant, he was dismissed. So it's very confusing, actually, and it's difficult to make head or tail of what was going on. But it doesn't make sense, and it certainly didn't answer my question.
Now, I'll move on to question number 4.
Yes.
Question number 4 says, is the specified company a licensed diamond trader? Now, who are we referring to when we say the specified company?
Scarlet Sky, the company that won the contract.
Yes. So is the specified company a licensed diamond trader and the premises licensed as a tender house? The answer is contained in page 272.
The answer that was given was that the diamond dealer license that SSI did not have a diamond dealer's license. It was in a different company called Diamond Trading House. I beg your pardon, called Daniel Nathan Trading.
Where does it say SSI does not have a license, Mr.
Okay, I beg your pardon,
Craythorne?
sorry. Can I just read it?
Yes,
Okay, in terms of
that's why I referred you to the page.
In terms of the South African Diamonds and Precious Metals Regulator, prescripts, a license is issued to an individual diamond dealer or to a company, Diamond Trading House. In this instance, Mr. Daniel Nathan is the holder of the required diamond dealer license.
Do they say anything about the specified company?
Nothing.
So do they answer the question of whether SSI has a license?
No.
Is it true what they are saying in their answer, that Mr. Daniel Nathan is the holder of a required diamond dealer license?
No, it's not true. The license is held in a company called Daniel Nathan Trading CC.
So none of this part of the question, of the answer is true.
With regard to the Diamond Trading House, I'm not sure regarding that license, but certainly in the case of the diamond dealer license, it's not true.
But Mr. Craythorne, they don't say anything about issuing of a diamond trading house license.
No, in their answer,
Yes.
they say. So
No.
I don't know if that answer is true, because you have a diamond dealer license, and then the premises that the diamond dealer conducts trading activities on has to be licensed as well.
Yes.
So I'm not, as far as I'm aware, there's no license for that as well, as far as Scarlet Sky goes.
You're conflating issues,
Yeah.
Mr. Craythorne,
Let me
because
not.
they don't say that Nathan has or doesn't have a trading
Okay.
house. They're just telling us the fact of how licenses are issued.
Okay.
That's all they're telling us there. Now, I want to take you back to question number 3A, because now I want to refer you to documentation. So question number 3A is the one that was asking on what basis was the company again awarded the contract in November 2016. And the answer was contained on the next page, in page 271. Now, we will note that it says, when it deals firstly with the wrong contract, in that it deals with the process that was followed for the 2014 tender process, correct?
Correct.
All right. And then at the end, it says, the Alexkor board appointed SSI with effect from 1 March 2018, which is also incorrect.
I agree.
So they don't explain why the company was awarded another contract a year after it had been awarded a contract.
They don't.
Okay. Now, just to complete that thought, can I refer you to bundle number 2? So it's a different bundle altogether.
I have the bundle.
Yes, please turn to page 263. Page 263.
This is mining bundle 2.
Yes, thank you,
What is the
Chair.
page? that-
263.
263.
It's underneath the tab marked 3.
Page 263.
Yes.
I have it.
Okay, this document is the agreement to market, value, and sell diamonds between Alexkor RMC JV and Scarlet Sky Investments 60 Pty Ltd.
Correct.
Now, if we take this document and turn to page 268, 268,
I have it in front of me.
In clause 4.1, it says this agreement shall commence on the signature date and shall continue in force for a period of 3 years. Do you see that?
I see that.
Okay. And then we can turn to page 284 of the same bundle.
I have it in front of me.
So we see in that page that the signature date is the 4th of March 2015.
That is correct.
So we know that this agreement started on the 4th of March 2015,
Correct.
appointing SSI to market and sell the diamonds for the PSJV.
Correct.
Now, if I take you further in the same bundle to page 295, 295.
I have it in front of me.
This document is called the Agreement to Market, Value, Sell, and Beneficiation of Diamonds between Alexkor CJV and Scarlet Sky Investments 60 Pty Ltd. Same parties, correct?
Correct.
Same kind of contract, correct?
Correct.
Okay, now I take you to page 300.
I have it in front of me.
If we look towards the bottom of the page, you will see in bold number 4, commencement and duration. Do you see that?
I do.
Now in 4.1 it says, similarly, this agreement shall commence on the signature date and shall continue in force for a period of 5 years. So the difference is that the previous one said it would continue for 3 years. This one says for 5 years. But this contract also commences on signature date, correct?
That is correct.
Okay. Now we go.
Did this one replace the 2015 one, or did they run parallel to each other?
That's the answer we don't have, Chairperson, because it's the answer that was not given at to the parliamentary question.
In the second agreement, does it not say what its relationship is with the previous agreement?
No.
Okay, all right.
And then on page 317,
I have it in front of me.
we can see that it now says this agreement is signed on the 6th of October 2016.
That's correct.
And as we have already seen, it starts from signature date. So this means that this contract started in October 2016, when previously they had signed with the same company in March 2015 for 3 years.
Correct.
So clearly, the question related to the second contract. The question in Parliament that said on what basis was the company again awarded the contract in November 2016. So they are talking about the second contract.
Correct.
Okay,
Well, Ms. Sibia,
the date is
the
different.
answer to my question is to be found in clause 30 of the second agreement. It says this agreement supersedes any previous agreements between any of the parties in relation to the matters dealt with in this agreement.
Yes, yes,
So the second agreement replaced the first agreement.
yes, yes. Thank you, Chair. Now, the question that has been posed was, on what basis was the company again awarded a contract in November 2016? We note that this is October 2016, but on a reading, do we know of any contract that was awarded to SSI in November as opposed to the one in October 2016?
No, they provided no clarity to my question that I posed via the parliamentary process.
Okay, I think you misunderstood my question. The question talks to November 2016, but we can see that this contract was signed in October 2016. You caused the question to be asked. Were you talking about this contract signed in October 2016, or were you talking about a different contract?
I was talking about the second contract because we had heard.
This contract?
Yeah, we had heard that there had been a subsequent contract.
Okay.
So, but that's all we were told.
Okay, so you assumed the time to be November 2016?
2016, yeah. So my understanding was that there had been a contract initiated in 2015, which was supposed to run for 3 years. Then we had heard via the grapevine that another contract had been issued in 2016.
Yes.
But no clarity as to how that came about was offered, and that's why I asked the question via Parliament.
So, do you agree that it is incorrect to say in page 271, paragraph 3A, Roman numeral V, 5, where they say, the Alexkor PSJV board appointed SSI with effect from 1 March 2018.
I beg your pardon, can you just refer me to that page number again? 271?
271, yes.
Okay, so
And the paragraph is 3A, Roman numeral 5, the V.
are we still in mining 02?
Oh, my apologies.
Okay.
I have left you behind.
No worries.
We are back in mining 04. My apologies, Chair.
Has it not become clear that a substantial part of that answer is not an answer to the question, and particularly about the basis on which the contractor was awarded?
Yes, Chair, but there's also the issue of the date, because,
2018,
yes,
but that's obvious, isn't it?
yes,
Yeah.
that the contract itself said it's effective on signature, and signature was in 2016.
Yeah.
So everything that was answered here was not true.
That is correct.
Thank you very much. Now, what else did you find out about that was not correct in the appointment? Because you haven't yet told us what you discovered was incorrect. You've told us that you asked and discovered that SSI did not have a license through your questions that you caused to be asked in Parliament.
Before you answer that question, can I just get this out of the way? As far as the second contract is concerned, that was not the subject of, that was not preceded by any competitive tender process, was it?
As far as I'm aware, Chairman, if I recall, I remember seeing a copy of a request for proposal, but I can't be sure on that because everything is so hazy, and it's difficult for me to keep track of it. But I do recall seeing something of a repeat.
Yes.
But I can't recall exactly where but it seems to me that to some degree there was some attempt to have an RFP.
Yes. Do we know what the answer is?
Yes, Chair, it's the one that Mr. Torres was answering about when he said he asked the company secretary what role they played. And the company secretary, Ms. Reagan Phillips, then said, although they were called a BEC, all they did was...
Where there was no evaluation.
Yes, yes.
Yeah.
So that's the second contract.
But did Ms. Phillips' response to him reveal that there had been a request for proposals or not really?
Chair, we didn't deal with that detail, but it is part of the report of the Kobodo report that to which Mr. Torres was testifying, and it appears that there was, but
Okay.
it seemed to have been a foregone conclusion. And
Yeah.
and he indicates that he does not know why there was a need for the second.
Yes, well, you'll just have to double check things with
Yes.
regard to that report, because it transpired while he was giving evidence that he was not asking some of the most obvious questions he should have asked.
Noted, Chair.
So if he has reached certain conclusions, we have got to, or made certain findings, we have got to double check that those findings are sustainable.
Yes, Chair.
Okay.
But in as far as there having been a process, that's the one that had the minimum requirements, and I referred us to the document that indicated the minimum requirements in the whole tender document that went out. So, but we will double check.
Yes, so what
yes.
I'm saying is, if they say there was no process, double check that that's factually true. That's what I want.
Yes, thank you. Now, can I take you back to the identified irregularities in relation to the appointment of Scarlet Sky that you referred to on page 6 of your affidavit? Now, I had asked, how did you get the detail? Because the detail in the affidavit is on the 21st of October, the process was initiated, and then you go on to detail what happened in the technical committee and the tender advertisement and all those things. So I had asked, how did you get this information for you to give it in this commission as your evidence?
Chairperson, there was a lot of unhappiness from the Richtersveld community over the issue of Scarlet Sky and the diamond prices and the manner in which the tender was awarded, and that led to a complaint being made by a attorney acting for certain members in the Richtersveld community, because there are divisions within the Richtersveld community. So this particular attorney was only acting on behalf of or under instructions from one particular faction. But he certainly
Did you get the information from the attorney?
No, that information, I got it from a gentleman called Peter de Wet, who's a Richtersveld member, who also made a complaint to to DPE regarding the Scarlet Sky issue. But flowing out of the complaint to the public protector, an arrangement was, and there was an agreement between the parties, between Minister Lynn Brown, the public protector, and that particular attorney, that Alexkor's own Audit and Risk Committee would do an investigation into the circumstances surrounding the appointment of Scarlet Sky. And as a result of that report, which I was given a copy of from Sam Sol, because I also blew the whistle to Amabangani in the early days, and Sam and I have shared information. So Sam, when he started doing queries into the whole Alexkor PSJV story, and which led to him writing quite an in-depth expose on it, he was given a copy of this document, which he passed on to me, and this document provides a lot of the timeline surrounding the appointment of SSA, when the need for a new marketing and sales service provider was identified, and then the events that followed.
Basically, that's part of where you got your information from.
That is correct.
Yeah, okay.
All right, thank you. Now, you say, you then go on to detail the technical committee meeting of the PSJV, which raised a concern regarding the manner in which diamonds
Where are
marketed.
you now, Ms. Beer?
My apologies. I am sure this time I have not left you in a different bundle. On bundle 4, on page 7.
Okay, all right. You may continue.
Thank you. I was reading from paragraph 25.
Okay.
And then it says, the committee advised that management request approval from the PSJV board to appoint a new service provider on a trial basis to determine whether there would be an improvement in pricing. And then you highlight those that were present at the meeting. Why?
Because those are the individuals that played key roles in the appointment, the ultimate appointment of Scarlet Sky, because they triggered the process that ultimately led to Scarlet Sky being awarded the contract.
Okay. And then you say that at the time, Rafiq Bahas chaired the joint board of the PSJV.
That is correct, and this information is drawn from the annual report, the Alexkor annual report.
Yes. Now, if we turn the page and move on to page 8.
I have it in front of me.
Yes. In paragraph 30, you say that SSI sent an expression of interest on 6 November 2014 on a letterhead that indicated the directors were Daniel Nathan and Kuben Moodley.
Correct.
You say this was wrong. Why?
Ms. Beer, some of the matters have been covered by your previous witness.
Yes.
Isn't it? And both of them, I think their sources are the same. It's just documentation.
Chair, he talks to a different aspect of irregularity that wasn't noted in the
All
evidence
right.
of the previous
All
witness.
right.
Yes.
The information that the Gabota report refers to is based on the appointment date, but when I did a company search, I worked on the effective date. So while they were appointed on the date that Gabota say, the appointment date is not the same as the effective date, because they as directors, they get appointed internally in the company, but the effective date as far as the registrar is concerned was on the 4th of December, which was even later, and I think that's relevant.
But you've gone ahead of me.
Oh, sorry.
Mr. Craythorne, I was asking you why you say it was wrong for SSI on the 6th of November to say that the directors were Daniel Nathan and Kuben Moodley. So we're talking about the 6th of November date.
At that date, the company that they ended up with was still sitting on a shelf. And there were standing directors, Moira, I think it's Moira.
So that's what's wrong. that
That's what's
they-
wrong, yeah.
This was not true, in fact.
It's not true.
And then it says, and then we get to your point, which is that when they became shareholders on the 20th of November 2014, and then you say for later on, until the 4th of December on paragraph 31.1, until the 4th of December 2014, the date upon which Mrs. Moodley and Nathan officially became directors. SSI was a shelf company, and the day on which they became directors was 11 days after the official closing date of the 24th November 2014.
That was my point.
And the evidence of Mr. Torres was that they were directors then.
Which is incorrect.
Now, you say it's incorrect. Can I take you back to that bundle that we've put away, which is bundle 2?
Before you do so, we are at 4 o'clock. Let's talk about what's going to happen so that we are all on the same page. I'm still quite happy to continue.
Yes, Chair.
But you raised the issue of curfews and so on, of which we may have to be aware.
Yes.
What would you like me to do?
Chair, I believe we can continue until 6 if no one is objecting to that. That would allow enough time for people, including my witness who's staying at a hotel, to get there at the right time. And the chair had asked me about the possibility of continuing on another day if by 6 we are not done. Chair, the witness is available to continue on Monday.
Okay, Mr. Craythorne, you are quite happy that we continue until 6?
Yes, Chairperson.
Yes, Council. Mr. Palm,
Be fine with it.
you're fine. Okay, thank you. Let's take a 10 minutes break now, and then we'll come back and continue.
Thank
We
you.
adjourn.
All right.
there may be some, we should have enough time to finish his evidence first. So we might not need to go up to 6 o'clock, but if there wasn't much space on Monday, then we would have to use every minute that we have this evening. So I think let's go up to 5:15.
Thank you, Chair.
Okay, all right. Thank you.
Thank you. I was referring us back to bundle 2, mining number 2. If we can turn to page 286. Okay, this is,
Is it quite hot inside here? Or is it just me?
it is,
I think
Chair.
Mr. Palmer indicates it is hot. Maybe the technicians can switch on the aircon, but so they must just make sure it doesn't make too much noise. Yeah, okay, all right.
Thank you. I will adjust my voice accordingly, Chair.
I don't have a lot of hope that you will succeed.
I will
But,
try my
I'm willing
best.
to be proved wrong.
Thank you, Chair.
Okay. Let's
No.
continue in the meantime.
Thank you, Chair. Now, Mr. Craythorne, this document that appears on page 286 is a company report on Scarlet Sky Investments 60, correct?
That's correct.
Did you source this document?
Correct.
Okay. Now, I would like us to go to page 292. If you look towards the bottom, you will see where it's written in orange, company change history, correct?
Correct.
And then if you go on to the next page, 293, and you look at the third date from the top, what is contained there?
Third from the top was the Director Daniel Mark Nathan details was changed, and that was on the 4th of February.
Well, sorry, just tell us first what the third date from the top is.
4th of
4
February.
February 2016, is that correct?
That is correct, Chairperson.
Yes. And then there's a column where it's written director stroke member, members, secretary, trust, both director and officer, and then there is something written against that. Just repeat tell me what it is.
It says director / member / secretary / trust / both director and officer, followed by Director Daniel Mark Nathan details was changed.
Okay, thank you. Now, if you go down, further down,
I'm sorry, what is the document? What is the nature of that document? What document is this? It's a company report.
it's a company report on Scarlet Sky.
For Scarlet Sky Investments.
Yes.
Okay, so
Sourced
it's
from
a document issued by the same company.
Yes, it's the company, it's the document issued by LexisNexis, yes.
Yeah, okay, all right.
Thank you. And then if you go further down, back on page 293, Mr. Craythorne,
Yes?
if you go further down, so you are on the third one, and you go the fourth, the next one is the 4th of February, the one below that is the 12th of August 2015, the one below that is the 4th of December 2014. Can you read that one?
Again, it says director, member, secretary, trust, both director and officer, and then followed by director Daniel Mark Nathan was added.
What does this mean?
This means that his appointment only became effective on the 4th of December 2014.
And then we go below that, and we see on the 4th December 2014 again.
Well, I'm sorry, now that you have asked that question, let's go back to the third date that we have dealt with regard to Mr. Daniel Mark Nathan. There it says his details were changed. Do you know what that means?
I believe that could have been in relation to a share holding change, possibly. I'm not sure.
You are not sure what it means?
I'm not sure, Chairperson.
Okay, all right.
Thank you. So if you go to the second date, that is the 4th of December 2014.
It has the same preamble, followed by Director Kuben Theron Moodley was added.
And what does that mean again?
That means that his directorship only became effective as of the 4th of December 2014.
Now, we already know that the tender closed on, they submitted their tender in November 2014. Were they directors when they submitted the tender on behalf of SSI as directors?
No, they weren't.
So should they have been appointed just on that point alone?
No, because this is a false representation. They represented themselves as being directors of a company that was bidding when it's not true.
So if we go back to that other statement in that other document where they said, in answer to the question, did they have a proven record at the time? And they said no, until Nathan joined them with his experience. So the question was, did SSI have the experience? And the response was, they didn't have a track record until Daniel Nathan joined them. Is that true? As at the time they submitted the tender, was Daniel Nathan in fact part of SSI?
His experience was of no consequence to SSI's tender.
Yes, because he was not even a director at that time. So that's another reason. That's something else that you discovered was not correct.
True.
An irregularity. This was talking to your paragraph 31.2, which is where we were on page 8 of your affidavit. So
Are
this
you
was,
asking us to move back to the other bundle?
yes, Chair, the other bundle. Thank you.
Just announce each time you move from one bundle to another so that we can move with you.
My apologies once again, Chair, for that.
Okay, we're going back to mining bundle 4A,
Yes, yes, Chair.
and you are at page,
8.
okay.
So basically what you say, Mr. Craythorne, in your paragraph 31.2, you say, the date on which they became directors was 11 days after the official closing date of 24 November for formal written proposals to be submitted in order to compete in the tender.
That is correct.
So if a due diligence had been conducted, which we've heard in the evidence of Mr. Torres, that it was not. It would have showed these things, and SSI should not have been appointed.
That is correct.
Now, from the evidence that you've given, it seems that these were things that were easy to find.
That is correct.
What does it tell you that these things were not highlighted and instead SSI went through the short list and the appointment?
It tells me that it was a foregone conclusion, a fait accompli.
And what did you make of that?
I made of that it was classic state capture.
And this was because?
This was because the modus operandi that was being followed here was a dead ringer for the other known examples of this behavior.
Sorry, I didn't hear the last part.
This was a classic example of other state capture projects that had already been revealed in the public domain.
And then in paragraph 32, before I go to paragraph 32, you've already said that Kuben Mudli had been linked with state capture, according
Correct.
to your investigations. Okay. Now, in paragraph 32 of your affidavit, you tell us about an investigation carried out in 2015 by the Audit and Risk Committee of Alexkor, as instructed by Minister Brown.
That's correct.
In paragraph 32.6, you set out an extract from the ARC report. What is the significance of this extract?
May I just take some time to read it?
Okay, maybe let me direct you correctly and not directly direct you to the extract first. In the paragraph above that, 32.5, you say that at the final selection, only 3 people sat on the panel at Alexkor's Rosebank, Johannesburg head office. Now, this is part of what was contained in the report, correct?
That's correct.
So this is not your own information. This is what you got from the report.
Correct.
And it says these were the people, Bachas, Duncan Korabi, and Dr. Roger Paul.
That is correct.
And you mentioned that Korabi awarded SSI a full 100% mark.
According to the Gamiro report, that is true. I beg your pardon. I think it's in the Gaboda report that I picked this up. The fact that 100%. I'm not sure if I can't recall if I picked it up in the ARC or in the Gaboda report.
Well, you picked it up in the ARC report because you say in paragraph 32, an investigation was carried out.
Okay.
The ARC report to Brown revealed the following.
You're quite right. I beg your pardon.
Yes, the day has been long, we understand, Mr. Craythorne. Now, you say in paragraph 33 that it appears that there was a significant lack of clarity about SSI's proposal and what exactly SSI had committed to in terms of funding, pricing, beneficiation, etc., which resulted in a delay in finally awarding the tender to SSI.
That's correct. Dr. Roger Paul had raised concerns regarding the commitment to community upliftment, and the issue around the valuation and whether or not that was an appropriate way of ensuring that Alexkor would achieve the best prices. And I don't recall all of the concerns they had, but there was a flurry of emails in late December whereby Mr. Carstens was anxious to inform Scarlet Sky that they had been provisionally awarded winning the contract. There was hesitance on the part of Dr. Roger Paul, Alexkor, but ultimately Mr. Carstens was given permission to inform Daniel Nathan and Mark Chipkin, who was, I believe, who was on correspondence that I've seen, he was the Chief Operating Officer of SSI at the time that the tender was taking place. And Mr. Carstens informed them that subject to him doing a due diligence in January, they had been successful.
Now, you say in paragraph 37, in fact, in paragraph 37, you make a number of conclusions. Are these your own conclusions, or are you quoting from a document?
These are my own conclusions flowing out of information that I had gathered in my slap suit defense.
So in paragraph 37.1, tell us what you say there.
Whereas SSI's original proposal was to procure rough diamond production through an outright purchase of production at the price determined by an independent diamond valuer, SSI was permitted to change its bid proposal to the selling of rough diamonds through an auction process to the highest bidder. This favored SSI and afforded it a competitive advantage over other bidders. SSI was also permitted to include 1.5% handling fee for handling the rough diamonds.
And then in paragraph 38, you say it seems self-evident that the outcome of that process was a foregone conclusion, as you've just testified, and that the process itself was a mere sham put on by the PSJV management team, headed by the CEO Carstens, to try to create a facade of compliance with the required procurement processes. That is your own conclusion?
That is my own conclusion, yes.
And then in paragraph 40, you say, having won the tender, SSI went from being a dormant shelf company to suddenly appearing on the local diamond trading scene as the PSJV's new marketing and sales service provider, taking delivery of its first tranche of multi-million rand rough diamonds on 15 March 2015.
At its new offices located at 1 River Street, Houghton, Johannesburg, that's correct.
Yes, that's what I wanted to check. What did you want to highlight there?
What I wanted to highlight there was the fact that a considerable amount of money had been spent in anticipation of winning this tender.
So the new office was created in anticipation?
Yeah.
All right. Now, you say in paragraph 42, as will be demonstrated below, the awarding of the tender to SSI and the subsequent renewal of its contract has contributed to the collapse of Alexkor, and with it, the economies of Alexander Bay and Port Nolloth and RMC.
Correct.
Is that part of the reason why you came here?
Absolutely.
Now, in the next section, you detail the links between Scarlet Sky and the Guptas. We know that some of this was not your own investigation, and you mentioned that it was part of it was dealt with in the investigation by Peter Bishop. Can you talk to these findings? Was any of what follows between paragraph 43 and 48 your own investigation, or is this based on the investigation that you refer to?
This is my own information, or
Okay.
but I may have drawn on documents that were provided to me, but I don't see anything here that,
You did not find yourself?
yeah.
Okay. Now, in these paragraphs, you mention the links. Can you tell us what the links are without necessarily repeating what's in the affidavit? These are the links between SSI and the Guptas,
Yeah.
as discovered by you.
When you look at the individuals that are involved with the outcome of SSI being inserted into Alexkor's diamond value chain, they are all very well-known individuals in the public discourse around state capture.
Other than Moodley, who would you be talking about?
I've mentioned here Malusi Gigaba, Mozabenzi Zwane, Rafik Bachas, Mervyn Carstens, Cuban Moodley, Percy Koza, Kellerman, Hansi Matseka, Daniel Nathan, Selwyn Nathan, Mark Chipkin,
Yes.
and Salim Essa.
Now, tell us, you say in paragraph 48.1 that Malusi Gigaba was instrumental in the awarding of the tender. Now, we know that the tender was awarded in March 2015, and that Malusi Gigaba was no longer a minister at the Department of Public Enterprises at that time. So when you answer the question of why you say he's the first person you list as having been instrumental in making sure the award was made to SSI.
The name came first to mind because this is when the state capture project actually began, with the appointment of Malusi Gigaba and him gaining influence over the strategic future of Alexkor. So in my mind, he was involved, but I will concede that he was not directly involved, but he was certainly laying the groundwork for what was to come later. So I'll concede that it's not correct to say that he was directly involved, but he was certainly a pivotal player in the overall theme of state capture at Alexkor, running from 2010 to where we are today.
Yes, and in 2010, what happened?
He became Minister of Public Enterprises.
Now, sorry to take you back because I've taken you to paragraph 48, but I need you to go back to paragraph 44. In paragraph 44,
I'm sorry, just to make sure that the two of you are on the same page. Mr. Gigaba was appointed as Minister of Public Enterprises with effect from the 1st of November 2010. He replaced Ms. Barbara Hogan.
That's correct.
And I think he remained Minister of Public Enterprises until 2014,
Yes.
after the general election.
yes.
So if you look at the term or the period during which he was Minister of Public Enterprises, are there any decisions that he made relating to Alexkor which you associate with him having played a role in the alleged state capture, alleged capture of Alexkor?
Yes, Chairman, because Malusi Gigaba, or ex-minister Malusi Gigaba, was instrumental in repurposing the board for for the purpose of taking Alexkor ultimately out of diamond mining and into coal mining, which I view to be an absolute strategic blunder of epic proportions, and was one of the issues that I tried to deal with by confronting the Portfolio Committee in Parliament over this strategic decision. And I wrote a report to Parliament trying to raise the alarm bells, but ultimately all of my efforts to draw attention to how catastrophic it would be to take Alexkor, which had just resolved the Gordian knot of the land dispute, and was all set now to recover and rebuild itself after that internecine fight, was now going to be misdirected into a misguided strategy around coal when it had absolutely no, in my view, strategic reason to want to go there. It had every reason to want to focus on the marine diamonds because there is such an enormous future in marine mining on the west coast of South Africa, and you can see it in Namibia. Namibia has a flourishing marine mining industry. They are investing trillions in building capacity, and we sit with a moribund industry on the other side of the maritime boundary.
Now, you mentioned that you communicated with the Portfolio Committee in Parliament to try and bring this issue to their attention. Do you have copies of correspondence between yourself and the Portfolio Committee, and are they here in the bundle?
Volumes.
Okay, all right. That's important, because part of what the Commission is looking at is what was Parliament doing about some of these matters. One, which may have been in the public domain, two, which may have been brought specifically to their attention by members of the public. So it's important to have that evidence to say, here is a member of the public who brought these matters to the attention of Parliament. What was Parliament's response? Did they acknowledge receipt? Did they respond in substance? What did they do about it? Or were these pleas simply ignored?
They were simply ignored.
Okay, thank you. Ms. Beer?
Thank you. I'm trying to decide whether to continue the vein where the chair has started or to finish the part I was dealing with. I think I'll finish the part I was dealing with and then continue in this vein. Thank you. Mr. Craythorne, I was referring you back to paragraph 44 on page 12.
Yes.
Where you set out the group structure that was submitted with the proposal for the first tender by SSI. Now, at this time, 60% of the shares were owned by a company represented by Moodley, and 40% was owned by DNT, represented by Daniel Nathan.
Correct.
Okay. And then in paragraph 45, you tell us about the current shareholding. Now, who told you about this current shareholding?
This current shareholding, I'm not 100% sure. It could have come from, I have to refresh my mind because I've drawn on so many sources. I think it could have come from the Commission's investigators or Mr. Henk Smith. I honestly, I can't remember offhand.
Okay. And it says, because I want to know whose opinion is this reflected in paragraph 45.3. Because in paragraph 45, you then set out a different shareholding reflecting 30% owned by the Richtersveld Community Trust, DNT still owning the 40%, and then in 45.3 you say 30% was owned by a black female who Daniel Nathan informed a Democratic Alliance Member of Parliament, Veronica van Dijk, when she visited the premises in December 2018, that this member, this black female is Reagan Phillips. And then you say that company searches could not confirm this.
That's correct. Ms. Veronica van Dijk, her constituency is Namaqualand, so it's not her portfolio. Mining is not her portfolio, but she has great affinity for the people of Namaqualand. She's seen the devastation left behind by the terrestrial mining activities over the past 70 years. And she was introduced to me by a fellow female diamond diver. There are female diamond divers who said that Ms. van Dijk was quite passionate about the Richtersveld and Namaqualand and wanted to learn more. And that resulted in a friendship whereby she would help me try and get answers which I was unable to get through any other means by launching questions in Parliament. So there were a whole series over time of questions, and one of the things that Veronica revealed to me was because of the questions that she was asking in Parliament, she was approached by certain individuals who I haven't mentioned in my affidavit, so I won't mention it here, who were concerned about the questions that she was asking in Parliament and assured her that she was effectively barking up the wrong tree and there was no substance to what myself and others were saying in the EAC, and invited her to go and attend the auctions. I've never attended the auctions because there's no point in attending an auction without having access to data. It's pointless. So Veronica did go, Ms. van Dijk did go and attend an auction, met Mr. Daniel Nathan, and upon meeting Mr. Daniel Nathan, he informed her, according to her, that the shareholding that had been relinquished by Kuben Moodley had subsequently been taken up by two individuals, one of whom was the financial accountant of Alexkor, and the other was the company secretary, Ms. Reagan Phillips. But that was that I only was told that by Veronica, and I couldn't confirm it in any way, Chairperson.
Okay, thank you. Now I'm taking you back to where you were explaining why you say former Minister Gigaba was instrumental in the awarding of the tender to SSI. If I may just refer you to paragraph 49 on the next page, page 13, you start saying that at the time of the appointment of SSI, Bachas was both the chairman of Alexkor and of the RMC Alexkor joint venture. And then you say he was appointed the chairman of Alexkor by Gigaba in September 2012. When Bachas was appointed, all of the directors of the board of Alexkor resigned and 6 new directors were appointed. What were you saying here?
What I was saying here was that the board had been reconstituted to fit his vision for Alexkor becoming a coal major.
When you say his vision, who is the he that you are talking about?
That is the vision which was announced by both Mr. Gigaba as well as the deputy minister at the time, and it was also given in his testimony in, I think, 2018 before Parliament on the Eskom inquiry, he was asked by the Minister, by the Portfolio Committee Chair lady, I think Ms. Ngangi Gobashi, about what he had done to advance emerging black miners. And he repeated that he had intended to develop emerging black miners by redirecting Alexkor out of diamonds and into coal, and into partnering with emerging black coal miners to supply coal to Eskom.
Was it not strange to take a company that is based where Alexkor was based, where it had been dealing with the mining of diamonds, and say it must now also direct its attention to coal mining in Mpumalanga?
Absolutely, but the reasoning given was the PSJV, and the fact that the PSJV had effectively sidelined Alexkor itself as a company, because Alexkor would only have oversight. So, in principle, in some respects, there was nothing wrong with Alexkor looking for an alternative revenue stream. But there was something very wrong in doing it when it wasn't budgeted or costed. So the money to support all of the activities that were taking place, all of the consultants that were being paid to pursue a coal exit strategy, was coming from the efforts of myself and my fellow diamond divers. So while we were producing very profitably for the PSJV, a lot of money, a significant amount of money was being invested in these coal mining ambitions. And you could see Alexander Bay as a town deteriorating. You could see our operations and the support of our operations deteriorating. And still the money kept on flowing. And Parliament raised the issue in 2016 when I attended the Portfolio Committee briefing. Because it had been announced already in 2013, I think, in the annual reports, that Alexkor was going to start pursuing coal mining opportunities and various other opportunities beyond the Richtersveld. And my argument was, it cannot be fair that enormous amounts of money are being expended by Alexkor pursuing projects funded by people like myself that don't have any intention of benefiting us.
Yeah, okay. Ms. Beer?
Thank you. According to your knowledge, did Alexkor in fact even have the expertise to embark on this new direction?
I don't believe so.
And the resignation of the other board members to which you refer, of the board members to which you refer in paragraph 49, I think, when Mr. Burgess was appointed, do you know the circumstances under which they resigned? Were they asked to resign? Did they decide to resign on their own in protest to something? Or what was the position? Or had their term come to an end? Is that something you know, or is that something you don't know?
Chairperson, at some point I remember tracking down Dr. V. Macon. I believe at the time that I got hold of her, she was living on the West Coast. I think she had retired. And I had a very long and cordial discussion with her, trying to find out what was going on, and I couldn't get
a straight answer.
I couldn't get a straight answer. No.
Yeah. Okay. So at this stage, all you are able to say is they resigned, yeah. But what the reason was, you are not sure.
Yeah.
Okay. All right.
Thank you. In paragraph 50, 5-0, you then link Mr. Bacchus to the board meetings of
course,
Alexkor.
Mr. Mayor.
Yes.
It may be that when they resigned, they would have finished letters of resignation, and those may be on record within the company, and maybe some of them would have stated the reasons. So that can be checked. The reasons may be relevant.
Thank you, Chair, I'm noting.
Because in other SOEs, there's been evidence of certain people being pushed out of certain positions so that others would be appointed. And then certain things happened after those appointments have happened. So it's important to check whether the reasons for the resignations may have anything to do with that.
Thank you, Chair. We will follow up on that. In paragraph 50, Mr. Craythorne, you mention that Bacchus attended the Alexkor board meetings as well as those of the joint venture, including those of the 23rd January 2015 and 29 January 2015, where the decisions to support SSI were made.
That's correct.
And then you say, after the meeting of 23 January 2015, Korabi resigned.
Correct.
This is the same Korabi that had scored 100, that had scored SSI 100.
That's correct.
Do we know why he resigned?
In the Audit and Risk Committee report that was compiled for former Minister Lynn Brown, it was recorded in that report that Mr. Korabi resigned around the time that the due diligence was not being done. And Mr. Korabi had raised quite a lot of objection to the award without a proper due diligence. And further information was revealed to me by way of Mr. Sam Sol from Amabungani, who shared the information that Alexkor had provided him in response to questions he had asked the PSJV board in response to prompts from me as a whistleblower. And in the response that he had got, and in the report, in the article that he wrote for Amabungani, I beg your pardon, he mentioned that it was a burning issue for Korabi, which is curious because he awarded him 100%, but then was extremely unhappy when they were appointed without there being a due diligence.
Thank you. You carry on to speak about Custons, and you say he was appointed as the CEO in paragraph 52 on page 14. You say he was appointed as the CEO of the joint venture in August 2012. And then you mention in the next paragraph that the Audit and Risk Committee meetings were attended inter alia by Custons, Dr. Paul, Dr. Briscoe, who were present at the meeting of the 15th of January, where the decisions to support SSI were made, and that these are the same people that attended the technical committee meetings. So you are linking again Custons, as you indicated in paragraph 48, that these are the people that were instrumental in ensuring that the tender was awarded. Now you say they are Gupta associates linked to state capture. Why do you say Custons is a Gupta associate linked to state capture?
Well, because Carstens compromised himself so obviously in an effort to accommodate what a Gupta Link company was executing upon Alexkor. So his behavior is the basis upon which I link him to the Guptas. Because no rational person would have done that.
Yes, in the face of all the shortcomings with the SSI tender.
And also the vicious response and a relentless victimization that he inflicted upon myself and other contractors that tried to raise valid concerns regarding the Gupta links of this entity. He defended them viciously.
And we won't forget that he indicated there had been a due diligence.
Correct.
No evidence existed. And when in fact, the company secretary said there hadn't been.
That is correct.
You move on and you deal with Khoza, Mr. Percy Khoza. You deal with him in paragraph 54. And you say he was appointed as the CEO of Alexkor, and he was a mining executive with both diamond and coal experience. And then you make you draw a conclusion that he was hired in part to pursue Alexkor's diversification into coal approved by Gigaba. Why do you say that?
Because he told me personally in a meeting in Cape Town during one of the Indabas, I forget which one it was, I forget which mining Indaba it was, but I had met Mr. Khoza and he had told me in the presence of a former Alexkor chief executive, as well as a colleague of mine from the marine mining industry, that he had been brought on board to execute the coal strategy, but he was going to resign from Alexkor.
Okay, then you go on and you deal with Mr. Moodley, whom you've already told us. And in paragraph 57, on page 15, at the top of page 15, you say that a number of media reports have linked Moodley to the Guptas and to the erstwhile Minister of Mineral Resources, Zwane, who is infamous for his involvement in the Freedom Dairy project, which paid for the Gupta wedding.
Correct.
And you mention that you have noted that in the commission, witnesses have stated that Moodley assisted Trillion Capital to loot Eskom and assisted the Guptas in acquiring Optimum Mine.
Correct. That flows out of the Public Protector's report as well.
And then you carry on. Would you like to read the last line there?
It would appear that he has also assisted the Guptas in looting the diamond resources in the Richtersveld for their Daniel, Nathan, and other connected persons' benefit.
And then you move to Mr. Essa. Do you have personal information in relation to Essa's involvement? I note that you mentioned that much of this was discussed in Bishop's affidavit, so that's why I don't want to go into it if you...
Yes, and also Essa's links were also made public via, if I recall, you see, a key link in this was the integrated capital management, which had very strong links to Salim Essa, but was also had very strong links to Scarlet Sky, because Mark Chipkin was, in fact, the chief operating officer of Scarlet Sky at the time, that it was punting for the tender. So the Mark Chipkin links and the Trillion story, in my mind, positively linked Mr. Salim Essa to the SSI story.
On a lighter note, Mr. Craythorne, I wanted to say, I see that when you give an answer, you look at the evidence leader, and it's only when she doesn't look at you that you look at me.
I'm learning. I asked her to stamp her foot, but she said that would be too obvious.
Let's continue.
Thank you, Chair. I will draw no meaning from that at all. Thank you, Chair. You carry on and you mention Kellerman. That's Zarina Kellerman.
Correct.
Yes. We've heard of Kellerman in the earlier evidence of Mr. Torres.
She was the chief legal officer of Alexkor at the time that the SSI was being introduced. I did not investigate or look much into Ms. Kellerman. I know very little about what her links are, further than the fact that she was subsequently appointed as an advisor, I think, to, as I recall here, Mozabenzi Zwane, and there's also some emails where she was copied in during the period. So she was very much on board the process of bringing Scarlet Sky into Alexkor, but I'm not certain exactly what active role she was playing. So it looked to me more like, it doesn't seem to me that, I don't have any evidence of that I can say, well, she did exactly this or exactly that. But as the legal officer and with regard to her responsibilities for ensuring good governance, she could have done much more to prevent these governance oversights taking place.
You go on to mention Ms. Hansi Matseke.
It was very curious to me, as a marine miner, how Ms. Hansi Matseke could become the chairperson of Alexkor. My investigations in the public domain revealed her links to the former Premier of the Free State, Secretary General Ace Magashule, and her relationship. So there were certainly deep concerns for me when I discovered this, because it just added to the weight of the state capture theme that was developing.
And from the time frame that you give in this paragraph, that she was the chair of Alexkor from August 2015 to August 2018 to October 2018, you already testified that no, you did not. Sorry, I don't want to put words in your mouth. Do you know if she was the chairperson? Well, you say, yes, I'm sorry, I'm confusing myself. You say she was also the chair of the joint venture. So if you look at the time frame of August 2015 to October 2018, she was the chair at the time that the second award was made.
That's correct. And she was also the chairperson of the Free State Development Corporation. So it was a curious mix of credentials.
And then the last institution that you mentioned is Regiment's Capital.
Well, a lot of what I've subsequently discovered about Regiment's Capital has been through interaction with the Commission. But the individuals in Regiment's Capital, in Trillion, Integrated Capital Management, it seemed like there was a constellation of satellite entities revolving around Salim S's office in Melrose Arch. Even Scarlet Sky's offices at the time that the tender was placed, it was right next door to Salim Essa. So in terms of connecting the...
how do you know that? Is that because you physically did go there, or how?
No, I've seen letterheads with the addresses of,
Yes.
of the various companies and
Yes.
Information in the public domain, the Budlender report,
Yes.
and various other reports. They all
Yes.
they all talk about a Melrose Arch center of gravity when it comes to
Yeah.
state capture.
Yeah, well, it's important because, as you may know, there has been evidence in regard to ESCOM
Absolutely.
relating to Mr. Essa meeting with certain ESCOM officials at Melrose Arch in some offices there. So, but you say you base what you are saying on letterheads and information in the public domain.
Correct.
Okay.
On page 16 of the same bundle, in paragraph 62, you make a submission that the biased tender process and the involvement of the aforementioned Gupta-linked individuals are enough evidence to reasonably conclude that the insertion of SSI into the PSJV's diamond value chain was a Gupta-sponsored state capture project that followed the same modus operandi used by the Guptas in the capture of other SOEs.
That is correct.
And you carry on that there was not even a need for such a company to be appointed, for any company to be appointed in this role, in the next paragraph.
Yes, I'm going to read it and then follow it with perhaps some further explanation, if that's in order.
Yes, that's fine.
Paragraph 63 reads as follows: Indeed, there was absolutely no need for any marketing or sales company to promote the diamonds recovered by PSJV. Given the expert opinion of Charles Wyndham regarding the self-selling quality of Alexkor's diamonds and the example set by Zimbabwe state-owned diamond company who sell their own productions in Zimbabwe, I submit that if international buyers will travel to Zimbabwe to buy Marangi diamonds, they will certainly also travel to Alexander Bay to buy Alexander Bay's diamonds, Alexkor's diamonds. So Charles Wyndham is an internationally acclaimed expert on polished and rough diamonds. His company for many years was the government diamond valuator for the Canadian diamond industry. He was brought into contact with Alexkor around 1998 by the chairperson at the time, who was Advocate Nona Gaza, because Advocate Gaza had deep concerns already then about what was taking place. And she went and visited mines in Russia and did extensive research on the diamond pipeline, is what we call it in the industry. And as part of that process, Mr. Charles Wyndham submitted a report in 1998 to Alexkor, making it very clear to Alexkor that by tying themselves into an exclusive agreement with De Beers. At the time it was De Beers. It was costing at least 23% of what could have been achieved through a process of proper price discovery. And the report that Mr. Wyndham authored, even he as an expert based in London, knew that there is no better address in terms of diamond geology than the address that Alexander Bay has. It's got what in the mining industry they talk about a phenomenon called closeology. So you have scientific geology, but then you have closeology. So if you're mining diamonds hand over fist like they are in Namibia, you should be able to be mining diamonds hand over fist across an imaginary line in South Africa. It's the same deposit. So that's what closeology means. And that's a point that already in 1998, someone as far removed from Alexander Bay as Mr. Charles Wyndham was making. So regarding the quality of Alexkor's diamonds, he made it very clear that Alexkor doesn't need any marketing. The diamonds are so well-renowned. People will come and buy them in Alexander Bay. This whole story of marketing this and marketing that, it's all nonsense. It all opens up opportunity for state capture and for ravaging the value chain and the diamond pipeline.
Thank you very much. Chair, this is the end of this line of questioning, so I'm looking at the time as agreed.
Yes. Well, we can stop now, or we could go on for another 15 minutes, stop at 1:30. If that's fine with everybody, I think it will be fine with everybody. Maybe let's do that.
Thank you,
Just take
Chair.
the next 15 minutes, then stop at 1:30.
Thank you, Chair.
Okay.
The next section of your affidavit, Mr. Craythorne, you deal with how there was also a breach of statutory provisions. We are still on page 16. You deal with the provisions of the Diamonds Act.
That's correct. By law, you're not allowed to conduct licensed activities under the license of someone else. So the activities of Scarlet Sky, which were conducted on the strength of a license held by Daniel Nathan Trading, is not permitted. It's unlawful.
So in addition to the other irregularities in relation to their appointment, this was in fact unlawful for SSI to then, having been appointed, do what it was appointed to do.
That is correct.
And then you explain in paragraph 70, on page 17, paragraph 70, that there's even a prohibition on the utilization of unregistered premises as a trading house.
I'm not sure what the situation is now, but at the time, the premises that Scarlet Sky was conducting the auctions was not registered as a tender, what they call a tender house. So the premises themselves have to be licensed, as does the entity that is managing and conducting and directing those activities on those premises.
And then you take us back to that question that we've already dealt with in Parliament, and you draw a conclusion on page 18, at the top of page 18, paragraph 73.1, and you say, although Daniel Nathan is a holder of a diamond dealer license and a diamond trading house license, these licenses were issued in the name of DNT and not SSI. What is the significance there?
The significance of that is that it is irrelevant that he has a license. It is a requirement that the entity that is conducting the business and the premises upon which they are conducted, that entity has to have the license. It has to be in that entity's name. It cannot, it's like the driver's license, as Mr. Torres said. You cannot drive a car on someone else's license.
Okay. Now we move to a different section of your affidavit, and we deal on page 19 with the complaints leveled by the mining contractors. You start out by saying that the value has considerably diminished. You've already told us how you calculated the value by producing your own indices and doing comparisons. Now, you're telling us that in October 2017, you wrote to the company secretary of the JV on behalf of the EAC's members, and who had expressed their concern and anger about the ever-decreasing values attributed to the diamonds produced by them. Now, was this after or before you posted the pricing on the outside of the mine, the plant?
This was around the same time. I can't be certain whether it was before or after.
What was the gist of what you wrote to Ms. Reagan, Ms. Phillips?
The gist was effectively that there was no, first of all, there was a huge amount of discontent regarding the price performance. But there was also a lot of consternation about the lack of information about who these people were and you know, what was the reason for this dramatic drop. So the purpose of my letter to Ms. Phillips was to say, look, everybody is very unhappy about the situation. Can we get together as the EAC representing the contractors and yourselves, and can you start making some disclosures so that we can at least understand who it is that is behind this poor performance and how it is that they came to be where they are. And I also raised the concerns around the disappearance of our tailings, which was also a burning issue. I raised also concerns about the lack of disclosure in the annual reports, because it's vital for us, and in fact any user of an integrated report, to have segment information. You need to understand if there is cross-subsidization of business units, which are the business units that are performing well and which are the business units that are not. And if you don't have segment reporting, you have no way of understanding why it is that when you have a segment that you are a part of that is performing very well, it is that the overall enterprise is going downhill.
Now, you pointed out a number of things. What was the response that you received? Because to me, these sound like serious issues. So what response did you receive?
Can I read the response? Mm-hmm. Dear Gavin, your email 09 instant is noted. Any issue pertaining to the diamond sales and diamond pricing trends must be addressed directly with the PSJV. SSI is the marketing agent of the PSJV duly appointed by the board. We cannot provide information of a service provider to third parties. You're welcome to discuss any issues with SSI or any other service provider of the PSJV with management. Regards, Reagan Phillips. And
Yeah. And after this, you wrote another email, which is then when you went into greater detail, as you've just explained.
that's correct. Actually, it was the second letter that I went into the type of detail about what sort of transparency it is the contractors were seeking in order to gain some kind of understanding as to why their businesses were suffering as a result of such poor pricing performance. And I note in my affidavit that I received no response to that email.
Instead, what happened after that email? In paragraph 85.
After I raised serious concerns regarding the sharp decline in the prices of our diamonds, my and several other miners' contracts were cancelled.
So in the timeline, how soon after these emails were your contracts cancelled?
Well, before the contracts were cancelled, they were actually cancelled by way of non-renewal. So we had been contractors with Alexkor for many, many years, and the contracts would get renewed every 3 years or so. And what happened in our instance is the whistleblowers from the ESC did not have their contracts renewed, but in my case, because they felt that my behavior was particularly egregious to them, they actually blocked me personally. So before they cancelled my company's contract, they knocked me out as the key person involved in running the business and blocked my access into the mine. So that began what was to be the start of the decimation of my financial well-being, because that resulted in 16 months of shutdown without vessel insurance, which to this day I can't pay the insurance on my vessel. This year I nearly lost my vessel twice. Just before I came to the commission, I struggled in a big storm, a 35 knot wind where the moorings broke, and I had to go into the mine on myself and swim out to my vessel to save that vessel. If that vessel had gone on the rocks, that's the only thing my wife and my family have left. And we can't insure it because they're stealing our diamonds in the plant. So it's been a tough journey to get here, Chairperson.
Mr. Craythorne, you say it was yours and several other miners' contracts that were cancelled. Were there also people that had been vocal against certain things at the PSJV?
Yes, but not very vocal. Look, over the 4 years from the time that I first blew the whistle in Parliament in November 2016, it wasn't as if we came out guns blazing. You know, it started off with friendly requests to. I wrote to the Alexkor board and I said, look, there are things that are going on in Alexander Bay which have serious implications for you as the 51% owner in this PSJV, and with regard to your assets, your very valuable diamond assets that you need to know about. And I gave an undertaking. I corresponded with Jukisa Ranto, who was then the chairperson of the portfolio committee. She was very interested. And we found out in a subsequent meeting that we had, my colleague George and I, that her son had been threatened in a street coming out of school. Okay? She told me and George that she had tried time and time again to arrange an oversight visit to Alexander Bay, and every time she tried to arrange it, the answer was no, because it was too dangerous and the members of the portfolio committee's safety could not be guaranteed. The same allegations were made on record, it's in the Hansard by Honourable Cathy Labuskaghni, where she stated in a portfolio committee that she was told to stay away from Alexkor, and we need to find out who it is that was intimidating Zukiswa Ranto and Cathy Labuskaghni and going out of their way to make sure that Alexkor or the portfolio committee could not do oversight of what was going on in Alexkor.
What reasons were you given for the cancellation of your contract?
The breakdown of the trust relationship.
What were you told was the factual basis for the conclusion that there was a breakdown in the trust relationship, if this was clarified to you at all?
There wasn't much detail given.
Did you ask them to tell you what they were talking about?
Well, one colleague in particular wrote to Ms. Phillips. I could understand why they're upset with me, because I was going to the press, I was going to the media, but that had only come very late in the day. So there'd been a build-up of tension. So what became apparent to me, Chairperson, as a member of the public, that is, if you want to get people's attention, you have to put yourself in harm's way. They don't take you seriously. I had to put myself in harm's way and end up getting slap-suited by Webber Wenzel and top advocates. And then again getting another slap-suit again. That destroyed my business, it destroyed my sense of well-being. It's had an immense impact. But that's the kind of thing that you have to do before people actually start thinking, well, look, why is this guy so crazy? Is he a lunatic, or does he really have something that he has to be angry about or upset about?
And of course, sometimes what happens is that harm is visited upon you so as to deter others from following in your footsteps.
And that is why there's so much fear amongst that's why we don't have a support base. We don't have a power base, because when Mr. Wayne Cook, when my access into the mine was cancelled, Wayne simply wrote a letter to Ray Phillips saying, look, this is a bit heavy. And, she reacted very, very harshly to him, and that resulted in him having his contract cancelled. And when he asked for an explanation, they said to him, because you, Mr. Wayne Cook, are supporting Mr. Gavin Craythorne.
What do you think they would say in defending their decision to cancel your contract? What do you think they would put on the table? Do you think they would have nothing factually other than to really talk about what indeed happened, namely you were raising issues that they were uncomfortable with? Or do you think they would come up with some...
Chairperson, when I first rang the bell in late November 2016, my concerns were not about the Guptas. The Gupta emails had not surfaced yet. The whole state capture story had not really dawned on us as a country of what was going on. I was more concerned with white monopoly capital, state capture, because I had read Sam Peter Blanche's book, Lost in Transformation, and that woke me up to what apartheid was all about, to what, it's just, you have the insiders and you have the outsiders. So if you're on the outside, it's tough. And sometimes you can get on the inside, but then you've got to play the same game. So the only indication that I got was when I tried to point out to the Alexkor board, who I met in Parliament, listen, the issues that you need to start paying attention to. I told them that I believed that the PSJV had been captured by TransX. Okay, the entire PSJV top management is all TransX executives. And they're also part of, okay, let me not go there for now, Chairman. But it was very clear to me what was going on. And I tried to warn the Alexkor board that the narrative that there was no future diamond mining potential for Alexkor was a horrendous lie. And I, in fact, authored a report discussing the local geology, the historical production, and why it was so important to start focusing on the marine. And I initially got a very warm response from Zukiswa Ntlangula, who was a board member of Alexkor at the time. And when I met her in Parliament, I had a very good discussion with her, and I said to her, look, I'll put together a report for you, okay, but I need your support. All that happened was that she referred what I was saying to Mr. Carstens, and that resulted in a month later, just before the mine closed, I got called in to meet and face Mervyn Carstens and Ms. Reagan Phillips, who were livid with what I'd done, and they said, listen, I'm going to lose my contract. And I said straight to them, I said, listen, you've betrayed us, in terms of, the Scarlet Sky issue and, this Quesco plan which had emerged and so on.
Yeah, okay, all right. We've gone past 5:30. I think we must stop here, unless there is a question which you think shouldn't wait until Monday.
I have one question, but I cannot guarantee how long Mr. Craythorne will take in answering. So
Okay.
we can stop here.
Let it wait.
Yes, Chair.
Okay, we are going to stop at this time. Thank you to everybody for cooperation for us to work until now. We will continue on Monday then at 10 o'clock. We'll deal with other issues connected with Monday, on Monday, in terms of other witnesses. So we are going to adjourn. We adjourn.